Morning, and we are going to continue where we left off yesterday. But for today, because it's a new day, and I hope you had a well-deserved rest yesterday. And I need to mention yesterday I missed an apology, one apology from member class who sent an apology, and we picked that up after the meeting. So I have to put it on record for that apology on his behalf, and my apologies for that. And for today's record, as I welcomed you, my name is Maklodi Maseko, the Standing Committee Chair of Infrastructure, and I'll allow the members to introduce themselves, the officials that are with us to introduce themselves, and then we can online also. I see Mr. Diaz has joined us also today. So if we in that order, we can do the introductions and then we'll continue with the agenda for today. Over to you, members.
Thank you very much, Chair. My name is Kayla Murray and I'm a member of this committee.
Greet you, everyone. My name is Tim Class. I'm also the member. Thank you.
Good morning, everyone. Bulila Isaac Sileko, member of the committee.
Thank you very much. Can go through the officials.
Good morning, Chairperson. My name is Liwanindo from National Department of Public Works. Thank you.
Morning, Chair. My name is Romeo Mostop, Legal Advisor to this committee. Thank you.
Thank you very much. Online.
Good morning, Chair. Nicholas Diaz, Legal Services Department of the Premier.
Thank you very much. You can press any button that is close by to introduce yourself then.
Morning, everyone. My name is Pamela Masiko Kambara from the Department of Infrastructure.
Thank you very much. And I am with Shamise Jones and Masintle, and I think our Senior Procedural Officer, Lizette Lute, will be joining us. Honorable members, for today, if we have to continue, we are going to look at we start with the metrics of the comments, concerns, suggestions from members of the public at the public hearings on the expropriation bill. The idea is that we are going to go through this, and some of the issues that have been raised already yesterday, Mr. Ndu responded to them. So we will look at those, and I'm trying to delay a little bit to get Mrs. Lute to give me the document that I've asked her to do for me, because I've asked her to sort of to remove all those that already have been dealt with so that we don't have to go through the whole document. So we are going to go through this matrix to look at those that Mr. Ndu hasn't responded to yesterday, and then we can get clarity on those ones. And then after we are done, we are going to compile. Remember, this process is for us to be able to compile our negotiating mandate, which is due tomorrow. So today we have to finish this, and then after develop our own negotiating mandate that has to be sent to NCOP. But in between, after we are done with formulating our own negotiating mandate, we'll break for an hour, I think. And after we will reconvene because we have to give the procedural officer and the senior procedural officer time for them to compile it as they receive those inputs from the members. And then after that, we'll look at that, and that's where we'll need Advocate Masdorp to check if the suggestions that we do have, we are not outside the constitutional boundaries with it. So you'll have to bear with me. In between that 1 hour, it's where they will be busy, and it all depends. And I'm just suggesting an hour. It all depends how much input do you have. That is the contribution to the negotiating mandate, because it doesn't say that you can only do this much. So it's a blank check of what do you want to see that you are going to send to the NCOP. So without wasting any time, over to you.
Some time, please, Chairman, with your permission. I just want to, on our behalf, because we grew so close together, congratulate Member Murray on the big step that she took. And I just want to give you some advice. You don't find love in any marriage unless you take it in there. May God bless you.
Coach Mo.
Okay, so that was an official in the chambers that you are off the market. Member Mare. I just have to put it out there. It's not me. I'm just endorsing what my favorite member has said, that to officially announce that you are off the market. Okay. It will be always in the YouTube. Your great grandkids also, they will know that on this day, it was officially announced that you are off the market. So let's continue with the matrix today. Okay, so members, you've got we are going to start on number 8, the Mossel Bay Municipality submission. And on the Mossel Bay submissions, I'm not going to read everything that because that deals with the court already. We have that, we did that. And then the other one is the expropriation also. Already that was dealt with yesterday. And we are going to number 9, the citizen, which is Mrs. Gresham Barretta, which the comment is that she is strongly opposed to this expropriation bill for many reasons, especially it being unconstitutional. Okay, over to you.
Sorry, thank Chairperson. I was saying yes, the issue of constitutionality of the we have dealt with yesterday. So
Also that one we dealt with yesterday, and from number 10, Mr. Petros Dlala, which is a member of the public, and the unreasonable bill, which he calls unreasonable bill, says that Section 21 of Constitution is sufficient to expropriate land with or without compensation, taking each case on merit or according to court rulings. 2, the unreasonable bill has come about because of the national government failure to allocate available land, failure to support recipients of land to make it productive, and failure to monitor the sale of returned land by recipients who become landless again and complain. Corrupt allocation of land to comrades and exclusion of deserving individuals. For the government must give us statistics on how much land has been in possession of government since 1994, what percentage has been allocated from that, and what percentage of the allocated land is unproductive. What percentage of the allocated land has been sold by recipients, and what percentage remains unallocated? Number 5, how this bill could make recipients productive. 6, how would bill prevent recipients from selling the land? 7, how could this prevent corrupt expropriation and corrupt allocation of the land?
Person, I think a lot of issues that are raised here, they fall under the ambit of agriculture and land reform around the issue of restitution, redistribution, and land tenure. So in terms of the Constitution, we've covered it yesterday, because I think, it's raising again to say the Constitution as it stands, it allows expropriation without compensation. That's what they're covering here. But we are testing that. We said perhaps the provision should be that let's send the bill to the Constitutional Court to check its constitutionality. So I think we covered that yesterday.
Thank you very much, Mr. Ndu. What will I do without you? Okay, I'll start. Mr. Sean Jacobs. He says, I'm writing to you today to express a strong objection to the proposed expropriation bill. I believe that the bill is a clear violation of the property rights and will have a devastating impact on South African economy. As a concerned citizen, I firmly believe that a person's rights to their property are sacrosanct and should be protected under all circumstances. Property ownership is a fundamental pillar of individual liberty, economic prosperity, and social stability. It serves as the cornerstone for entrepreneurship, investment, and wealth creation, fostering a sense of security and stability in our society. Recognizing and respecting property rights is crucial for incentivizing innovation, fostering economic growth, and attracting both domestic and foreign investment. Allowing the government to dispossess individuals of their property, even under the pretense of public interest, sets a dangerous precedent that undermines the principles of personal freedom and ownership. While it is essential to balance public welfare and developmental needs, any infringement upon property rights must be subject to strict scrutiny and justifiable cause. I urge you to reconsider the proposed expropriation bill in its current form and seek a more balanced approach that respects and upholds the property rights of individuals. By safeguarding these rights, we can foster an environment that encourages economic growth, social stability, and long-term prosperity for all citizens. Number 12. Okay, input noted for number 11. Number 12 from Tanya Bippert, member of the public in Waterskloof. Once again, thank you that the provincial government included our rural areas in the presentation of the expropriation bill. And her submission or questions are as follows. Unutilized state-owned land should first be considered before expropriation takes place on privately owned land. What is the criteria of selecting the expropriation authority, and does this authority have the power to overturn the court of law's findings? Corruption is a big concern here. 3, if any South African heritage groups can prove that state-owned property is heritage ground, does this bill make provision for a heritage group to apply for expropriation of state-owned land? Mr. Ndu?
Chairperson, once again, I think, I'll say one or two issues that have been raised here. They are noted, particularly around the question of corruption, because, it's outside of our ambit and the bill does not actually cover that. But there are two critical questions that they're asking around the issue of South African heritage, to say that should they actually apply for the expropriation of the state land? From where I'm seated, I think it's a critical question that we should find expression in terms of your so that we could actually have a global answer to give to that effect. And the other one, they're talking about the powers of the expropriating authority. Whether they've got the power to overturn the decision taken by the court. I think yesterday we reflected to say that our court is the final arbiter in terms of actually settling the dispute that are adjourned to rise as a result of expropriation. So I think those are two critical areas that perhaps, in terms of their input warrant our attention. But by and large, we agree with what they've submitted.
Comment?
Chair, my sentiments are very much aligned with the comments that we've received here in the deliberation. But with your indulgence, Chair, I think I would like to expand on them in the negotiation a bit more.
Thank you very much. We are going to continue. I don't see a hand online also. If you can remove that recording thing. Okay, number 13 is Nina Bed submission. And she is a member of the public, and she says, I hereby exercise my implied right to make use of this opportunity to be heard and make representation in the form of additions before a decision is taken by the deadline 14 June negotiating mandate and 28th June 2023 final closing. Okay, it has been changed a long time ago. My additions are A, that the bill specifically includes for the public purpose and public interest in the prioritizing of the preservation and protection of our sacred heritage sites and natural sanctuary of its water, indigenous plants and animals. The preservation of the function of cultural heritage education centers together with community cross schools with the official recognition of the Kam and the Khoi languages. In relation to the overview of the state's commitment to land reform and reform to bring about equitable access to natural resources. B, and makes provision for A, grondgrepe van die plasse en die groter Mossel by Suid-Kaap, Eden District na groot word verneem ten koste van behuising. Begraafplaas, privatisering van die Groot Braakrivier, privatisering van die grond by die see, Vleesbaai, Gorikwa Private Resort veroorsaak dat mense nie toegang het na die plekke. Toegang na see en riviere word ontneem. Grondeise gebiede, historiese erfenisgrond, bloedgrond, sou wees Hwaing. En regte procedure was nie gevolg nie van verkeerd erfenisterreine, krye plante, rostekeninge, geen kultuurgrond, voorbeelde die Punt, Pinnacle Point en Blompos. Ons is geen deel daarvan nie. Moratorium, grondeise geld kompensasie en grondeisinsentiefs moet gekry word. Ek vra dat daar binne die bil ingebou word, binne die oorgangsfase moet daar 'n moratorium geplaas word op enige ontwikkeling vir 'n tydperk, al is dit 10 jaar wat die bil kan nie kom. Ek dink aan die grondeise proses. Ek wil net hê dat daar moet ingebou word in die bil ons as die breinmense, Khoisan of swart mense eens. Moet daar 'n regte kompensasieproses ingebring word. Die bil moet aan die Khoisan incentives gegee as die eerste inheemse nasie van Suid-Afrika moet wees. That was 14.
You read to Nina Bird stuff with a universe.
Okay, I read 2, which is the Nina and Mr. Berry. That's the continuation. Okay. Mr. Ndo is saying it's the same that we talked about there. Yeah. Okay, and then we are on 15. That was from Councillor Tandisa, the DA councillor in George. And she said the DA fully supports land reform and restitution. And the DA also believes that our existing land reform policies are not the problem. The reason why land reform has failed so spectacularly in this country is because of corruption and maladministration. The expropriation bill is not the answer to land reform. The expropriation bill has been drafted to give the government the power to expropriate property for its own use. The bill does not address what will happen to the land once it has been expropriated for land reform purposes. It's only a small part of this bill. Okay, that has been addressed. 16, Ms. Marlene Barnett, DA George Councillor. Also, private property rights are the cornerstone of any democracy, and a constitutional democracy exists where the rights of the individual are of greater value than the rights of the state. The expropriation bill creates a situation where the rights of the state carry far more weight than that of the individual. Under Section 2, subsection 2, the concurrence of the executive authority, which owns the property in question, is required in order for expropriation to proceed. No such right of refusal is granted to private property owners. In other words, the state may say no to expropriation, but a private owner may not. The rights of private property owners are further undermined by the fact that expropriation may take place prior to the finalization of compensation. And should there be any dispute about the value of the compensation, access to courts for assistance may take place after the property has already been expropriated. This puts the property owner at a distinct disadvantage in trying to enforce their rights to their property after it has already been taken by the state. Property that is not being used is also targeted for nil compensation under Section 12, subsection 3A. The fact that the state has the power to effectively confiscate your property because it determines that you are not doing anything with it, it is a total abuse by government and a direct infringement of private property rights. There is also no clarity as to how the determination is made, by whom it is made, or what the criteria are for this clause to be implemented. Until the rights of individuals are properly protected from the abuse by the state, we cannot support the bill. The expropriation bill speaks only to direct expropriation. This exists where the state takes ownership of property in order to meet a public purpose or public interest requirement. However, certain cases of indirect expropriation exist whereby the state can take custodianship of the land, or where land is identified as being fundamental to an environmental protection matter, and the owner of such land is thus unable to use the land for its intended purpose. In both instances, there is no actual transfer of ownership that would allow for a payment of compensation to the owner. Instead, the owner uses effective use of the land with no compensation whatsoever. We believe that the definition of the expropriation should also include such examples of indirect expropriation in order to ensure that the owners of such properties are duly compensated for the loss of the use of the land and the inability of the land to be used productively. By excluding indirect expropriation from the definition of expropriation, the state is creating a loophole through which they can gain access to land without being forced to compensate the owners. This is direct infringement on property rights, and until it is rectified, we cannot support the bill.
Chairperson, I think there are three critical areas. We've covered them yesterday. It's around the issue of clause 12.3, the issue of indirect expropriation. We have also covered it when we're dealing with, I think, the foundation, the Active Clear Foundation. Yes, on the basis of the background that they've given, they're not supporting the bill. So we noted their take on the matter.
Members covered? Okay. Thank you. 17, Kailetu lawsuits. The councillor also talks to the section 25 of Constitution, allows for the payment of nil compensation. In that, it says that just an equitable compensation may be paid. In certain circumstances, this could be nil. The expropriation bill, however, is more explicit, and in section 12, subsection 3, provides 5 circumstances under which nil compensation can be paid. It does not, however, limit the circumstances to just those 5. I think we dealt with that one. 18, Charlotte Clark, the councillor, section 12, subsection 3C, we dealt with that yesterday. 19, Cornell Barnett, the DA councillor, section 25, Constitution also is the same. So the proposal, what he mentions here is that the proposal to amend the bill, the DA recommend that there should be only 2 instances which nil compensation could be stipulation in the bill. The first is where the land is owned by the state and is no longer needed by the department or organ of state. The second is where the state property that was previously expropriated and paid for is needed for another purpose. Any other predetermined basis for the payment of nil compensation places the state in a better position than a private owner and should not be included in the bill. The Constitution already provides a basis for the payment of nil compensation, but it must meet specific criteria, including negotiations. And it goes back, to the section 12, subsection 3, it's a violation of the Constitution. Unless this is amended as we have proposed, the expropriation bill cannot be supported. And also the number 20, Carol Benjamin, also there is a question from her. She says, the issue with the expropriation bill in its current form is that it does not properly define property except to say that it is in line with the definition of section 25 of the Constitution. This creates a problem where anything other than land is going to be expropriated. Who will determine just and equitable compensation, and what access does the property owner have to courts in the event of a dispute? That also, it was, I think there's a uniform to the issues that are being raised. And Unatima Bulu from the councillor also raised the issue of the section 12, subsection 3, and also mentioning the section 25 of the Constitution. Then we have Mr. Wayne Bennett, a public member from Cape Town, and talks to the section 1 of the Constitution of the Republic of South Africa stipulates that in applying the Constitution. Okay, let me start. My name is Wayne Bennett, and this is my submission for this evening. Section 1 of the Constitution of the Republic of South Africa stipulates that in applying the Constitution, one ought to give a dignity to the process and achieve equality as one advances freedoms. And then goes to section 25 of Constitution, then states that no one should be deprived property except in terms of the law, which is something we are having a debate about today. Expropriation is necessary to address the historical injustices of apartheid and to redress unequal distribution of land in the country. And continues. If the masses are part of process of land distribution, expropriation, and acquisition, then they can take ownership and accountability of planning for the land and taking care of the position for social projects, economic possibilities, and other hope-generating initiatives. Expropriation process is fair and transparent to avoid any abuse of power by any party involved. Currently, there's no access to adequate information with regards to land distribution and processes required, and that opens us as a country up to abuse and mismanagement of the process. The party could also propose that the government invest in capacity building programs to ensure that they have the necessary expertise to implement the expropriation bill effectively. The party could argue that this would help to avoid delays and mistakes in the expropriation process, which could lead to legal challenges and further exacerbate the housing crisis. We need to address the housing issues in Cape Town, as it's imperative that equally important is a distribution of land to the township economy revitalization program, e.g. if one had to open a rehab facility in a township anywhere inland, we need to make the process easier to acquire the said land, lease and redone. That will grow the investment potential in various communities. The process of job creation is not an island to this conversation, but a collective of initiatives, and equal distribution of land is as important as any other initiative. That was a comment. Okay, and then we've got number 24, Mr. Zaronda Monse. And he says expropriation of land can only be considered once the Khoi and the San people are recognized by the government, and educating of Black Africans regarding the history of South Africa First Nation people gets prioritized. According to a land audit report, which only focuses on private land and ownership by race and nationality in the Western Cape, 57% belongs to white people, 8% African, and 16% colored, and Indian 11%, and other 7%. And it goes on to talk about it is time for African people to start acknowledging who their real enemy is, and it goes on, and at the end is only then can we continue with this bill that will return the heritage and land of the Khoi and the San people that was stolen. It is a comment. 25, Mr. N.A. Sunday, chairperson and farmer. The PHA campaign, his comment is that the PHA campaign supports the expropriation bill as proposed. The PHA campaign is a local community-based organization in the Philippi horticultural area in Cape Town. We represent a large number of landless farmers and farm workers looking for land to farm in the Philippi horticulture area. 26, Ms. Faranas Matthews. The DA fully supports land reform and restitution. The DA also believes that our existing land reform and it continues already. We have seen that one. And at the end, it says, lastly, the expropriation bill properly addresses the issue around the settling of mortgages and the threat of expropriation without compensation to the banking sector. We cannot and will not support the bill. 27, Ms. Yvonne van Tonder. Again, at the end is the same, the section 12, subsection 3C of the expropriation bill. And the last comment is that while we fully appreciate that the land question has become a crisis in this country, we believe that land reform remains possible if done properly, fairly, and without corruption. We further believe that we should be encouraging private land ownership with title deeds through proper processes rather than consigning our people to live in undignified circumstances, informal settlements on government land. By preventing land grabs, government can use properties for their intended purposes and ensure that more formal formal human settlements are established so that people can become property owner and create generational wealth. And again, it's section 12, subsection 3C of this bill will achieve the exact opposite, and we cannot support the expropriation bill while this remains an option. 28, Michelle Boats also talks to that, and at the end is a comment. We believe that the definition of expropriation should also include such examples of indirect expropriation in order to ensure that the owners of such properties are duly compensated for the loss of the use of the land and the inability of the land to be used productively. So by excluding indirect expropriation from the definition of expropriation, the state is creating a loophole through which they can gain access to land without being forced to compensate the owners. This is a direct infringement on private property rights. And until this is rectified, we cannot support this bill. Okay. And Meki Plato, Martins, Meki Plato, Mentor.
That me.
Yeah.
Okay.
Okay. So, also, again, is the last comment is in a proposal to amend the bill. You recommend that there should be only 2 instances in which nil compensation could be a stipulation in bill. The first is where the land is owned by the state and is no longer needed by the department or organ of state. The second is where state property for the payment of nil compensation, but it must meet specific criteria, including negotiations. And again, mentioning the section 12.3 that is violation of the Constitution. 30, Councillor Darlene's Labert. And again, is section 25, the Grondwet. And at the end, and she highlights the issue of that sommige van my vernaamste bekommernissen met betrekking tot hierdie wensontwerp is die volgende. 1, dit spreekt nie aan wat met grond gaan gebeur zodra dit onteen is nie. So it's also the same as the issue of the land use after expropriation. And the last comment is that totdat daar absoluut duidelikheid is oor watter eiendom onteen kan word en hoe dit onteen gaan word, kan hierdie wetsontwerp nie ondersteun word nie. Ek maak beswaar teen hierdie wetsontwerp. That's not support. And 31, Dion Bekir, member of the public. He says, hi, I also lost my property in the 80s. I wanted to claim it, but my dad died in 1996. What's the next option for me? I really need my ground. That's not me, it's the matrix. Yeah. Where do we direct him?
Land reform.
Okay, land reform, she means. Okay, 32, Mr. Jonathan Peterson, member of public. I do not support this bill, and the reason one cannot expropriate land that doesn't belong to you. The First Nation people were excluded by the CODESA negotiations, and the Constitution did not consult with the original Khoisan custodians of the land. 2, clause 12, subsection 3, we, the descendants of the First Nation people, want access to the 400 billion rent protected in the 1961 Colored Persons Community Trust Fund. Okay, I need to read to say this to understand. I'm sorry about that. Clause 12, subsection 3. We, the descendants of the First Nation people, want access to the 400 billion rand protected in the 1961 Colored Persons Community Trust Fund. I'm speaking as a resident of Wetwater in the Bergrivier municipality. Clause 24, Register of Expropriation, Mutlanti report, difference between ownership and possession. Those are questions he puts there. And then in written submission, he says, why were the indigenous First Nation people excluded during the CODESA negotiations? And how will the current government compensate to make up for the huge mistake? On what grounds do the state expropriate land that never belonged to them, but still is the property of the First Nation Khoi and or San people? Will the current government pay the 400 billion rent to the people residing in the Colored Persons Community Reserve Trust Fund of 1961 to the First Nation descendant? And the question to the clause 12 and section 25, subsection 3. Mr. Ndu?
Chairperson, I think there are a number of issues that have been raised here, and the relevant department, one, around the Mhlante's report, the president is, the president should be seized with this what called issue to deal with it, together with social development. The issue around clause 12.3, I think, it's an issue that we've actually spoken about, and section 25 as well yesterday. So those 400, the owners, the descendant, I think, the Mhlante report should actually deal with that, and the president can address that.
The Mhlante report, I think this is the Delrec one, the one on the land question. So it's not the presidency. The Department of Agriculture and Rural, I can never pronounce the acronym. They produced the Mhlante report on land.
Okay, no, it's fine, but I think let's put them there as well. We can say rural development, social development, and presidency, because you know why this report, the conference that are actually happening now, they are coordinated by president, and they come and present together with the advisory panel on land reform. So I think if you're correct, we can just actually club them together. They'll actually see. But I thought if we say presidency, given that all these commissions are actually, but I agree, can also factor that.
To recap the Mhlante report, if you have to highlight the direct issues to the expropriation bill, what will be that?
It was more, they were looking at the 10-year issues of the country. Sorry. The report, this was a couple of years ago, they were looking into the land question. I think part of that had to do with the audit of who owns land. But secondly, there were 10-year issues being interrogated in that report in the country, with the intention also to deal with the, what's the 10-year in rural areas? Traditional authorities and land ownership in that context, and how to devolve ownership to those households who live there because they don't own land. It was more dealing with those kinds of issues. It's been more than 10 years, I think they dealt with it now. Yeah, but it was under that Department of Agriculture and Rural Development. I can never pronounce the full name.
Yeah, but remember, since then, there's the advisory what you call panel, which also pick up from Mhlante's report. They clapped and they.
Yeah, that's the presidency one.
Yeah. No, that's fine. That's fine.
Okay, thank you very much. And we noted that one, the presidency. Okay, and 33, Mr. Jonas Poshoko from Ikamva Labantuan. So the input is as this is a written response by Ikamva to invitation by the Standing Committee on Infrastructure to submit written inputs and attend the public hearing. And it says Ikamva Labantwana, also known as ILB, creates educational opportunities for the most deserving children and youth from Crossroads and Nyanga area. Is the only independent educational program currently operating in Crossroads and Nyanga area. As it is known, Crossroads and Nyanga area is one of those overlooked communities with a high rate of crime, gangsterism, crime and drug or substance abuse, also referred to as the murder capital. ILB, as it is commonly known, works with learners from grade 4 to 7, and we provide them with daily homework support Saturday tutoring sessions and academic enrichment programs such as visual and creative arts during school holidays, and we also run a youth cafe. Therefore, our mission as ILB is to prevent youth from committing crime by providing them with skills development trainings to break the cycle of poverty, to access jobs, to be able to start their businesses in their communities. ILB also provides high school and primary school support by providing schools with unemployed matriculants and university students who serves as tutors to teach learners for life programs at school. And our youth cafe seeks to provide youth with a platform where they can access skills and personal development training, economic and social development opportunities, provide sexual reproductive health programs to youth to address the problem of teenage pregnancies, STI and HIV/AIDS infections, and create a space where youth from Crossroads and younger area can be able to express themselves at a local and global scale. Therefore, our mission is to see the youth of Crossroads and Nyaga equipped and empowered with skills to live a better life, free from drugs and gangsterism. Therefore, our primary mission objective is to transform the youth of Crossroads. And it goes on. The Constitution of South Africa, whereas Section 25 of the Constitution of Republic of South Africa, Act 108 of 1996, provides as follows: the property and no one may be deprived of property except in terms of law of general application. No law may permit arbitrary deprivation of property. And continue with 2, property and And 2, it says property may be expropriated only in terms of law of general application for a public purpose or in the public interest and subject to compensation, the amount of which and the time and manner of payment of which have either been agreed to by those affected or decided or approved by a court. The amount of the compensation and the time and manner of the payment must be just and equitable, reflecting the equitable balance between the public interest and the interest of those affected, having regard to all relevant circumstances. And it goes on. And again, it talks to public purpose, public interest. Also, they even go to the Oxford Dictionary, how it defines. That's again, Mr. Ndu, the issue of and it goes on of the meaning of those words, the interpretation. Okay. And they talk about the recommendations of the Joint Constitutional Review Committee of 2018, where they talk about the Section 25 and they quote the President Ramaphosa in Parliament, indicating our people are in need of land where they can build homes, farms, build facilities for various amenities. A number of these places are in urban areas. And the Lekotla of our government decided that we should embark on a rapid release of land. And they continue to quote him. And at the end, they say, we as Inkamba Labantuan, we agree with the President Ramaphosa's statement that people need land. There must be a rapid release of land of property in hands of local governments or municipality. Our organization is currently leasing a property that was used as a public library. This building was abandoned by the city of Cape Town for a period of 2 years. This place was now becoming a hiding spot for criminals, and it was then through the initiatives of public members that Inkamba Labantuan managed to occupy this building and start to run academic programs for youth and children of the Crossroads and Nyanga Township. So it's more about Inkamba Labantuan, and at the end, they're saying that therefore it is their submission that rapid release or land or property and expropriation of land without compensation is needed. The expropriation bill must be amended to allow expropriation without compensation in this regard. Section 25, subsection 1, 2B, and 25, subsection 3 are impediment to the expropriation of land without compensation. and needs to be amended. These provisions are problematic and are perceived to be protecting property rights acquired during colonial and apartheid days. That's the end of Ikamba. And 33, Mr. Kwandilam, that one is what is the repeat of everything that has been said. And Mr. Kwandiles Kosana, member of public, also talked to the issue of land expropriation in South Africa and the idea of an equitable expropriation bill is one, he says, fair and just compensation. One of the key ideas for a fair and equitable expropriation bill is the provision of fair and just compensation for the expropriated land. Compensation should be based on the market value of the land, taking into account factors such as the current use of the land and its potential for development. Compensation should also be paid in a timely manner to ensure that the landowner is not left without resources. That's a repeat also, public interests. That's what everyone has been raising, and the transparency and accountability. And he says, transparency and accountability are also important ideas for a fair and equitable expropriation bill. The process of expropriation should be transparent with clear rules and procedures for the expropriation process. The expropriation process should also be subject to oversight and review to ensure that it is fair and just. And that talks to the regulation too, yeah. And for consultation with affected parties also falls within the regulation. Compensation for loss of livelihood, that is what has been highlighted. I think for today is coming again and again in the way if you're going to expropriate a farm and the livelihood and it was up and running, what's going to happen in the meantime. So he says compensation for loss of livelihood is also an important idea for a fair and equitable expropriation bill. Landowners who lose their land as a result of expropriation may also lose their source of income and livelihood. Compensation should therefore take into account the loss of income and livelihood and provide support for landowners to transition to the new livelihoods. I think a lot they talking about the issue on when coming to this and said there should be accommodation of when expropriating where there is a functioning, like if it's a farm, what's going to happen to have a clause that talk to that in case of a farm or in case of a business being operating in expropriation. It mustn't be about the property only. It has to be also the income attached to that property that we have to talk to that. In conclusion, they say the expropriation bill public hearing in the legislature of Western Cape is an important step towards creating a fair and equitable expropriation bill in South Africa for all. The bill should provide for fair and just compensation, be based on the public interest, be transparent and accountable, involve consultation with affected parties, and provide compensation for loss of livelihood. By incorporating these ideas, we can create it stopped there, didn't continue. Okay, and 34, I think I'm not going to talk to that, or maybe if you can comment about that one for the record purpose here.
That are raised here, and they're making sense, particularly in terms of the 5 compensation for the loss of livelihood. So that's noted, and perhaps going forward we'll look into that and see how it can actually get expression in the draft assistance.
Thank you, members. Covered. Okay. The communique also did their submission by Mr. Neville Peterson. Now it's a tenant of communique. As I say, it's a tenant of communique, and it's talking about talked about the history of communique from the rental stock, and then they were asking for the title deeds. I still remember title deeds for the rental stock where they are living and where they are renting. Yeah, so that's it. I summarized everything. Remember, Silek? Okay, so he said at the end is that in terms of the constitution, the community would like to own those houses and have title deeds. As tenants, they had dreams and aspiration to own their own properties. They will pursue whatever mechanism there was within the legal framework to seek an opportunity to buy those stocks. They were asking for title deeds. So in principle, it's, yeah, is it. So 35, Mr. Rob Manzoni, member of the public, he just wished to register strong objection to the expropriation bill, that's all. And number 36, Stefan, I can't say that surname. Bowitz, okay, member of public. He said, I would like to provide feedback that I oppose the proposed expropriation bill sitting before NCOP currently. And then his objection is, his objections are, the proposed bill does not provide for a final decision to expropriate, including without compensation, to be made in court at the Okay, sorry. The proposed bill does not provide for a final decision to expropriate, including without compensation, to be made in court at the state's expense. This would ensure a balanced oversight and prevent too many powers vesting in the minister to decide to expropriate. This would ensure all merits of the case are properly understood and must be aligned with common law and the Constitution. My concern boils down to trust. One, will the state do the right and fair thing for all parties involved in any expropriation decision? Two, will the minister abuse his privileges and expropriate land for corrupt purposes? Ensuring the court makes a final decision and that the court costs are for the state ensures individuals who may have property expropriated are able to defend their case. The meaning of the word property not applying exclusively to land. In many cases, clauses are specific if the property is land, but there are no specific clauses on what happens if the property is not land. The process of valuing the property seems open to abuse, including in the case where the property is not the land. The bill needs to be more specific who can determine value and how agreement on value is determined. The land court must be staffed with judges from the South African judiciary, too much power vested in the minister. Sandu, any?
That yesterday, and the issue of the court, the land court, remember when we're talking about the court must actually make a final determination, and therefore the court are overwhelmed. And then we spoke about the envisaged land court to say expropriation matters are going to be actually dealt today. So I think by and large, a lot of issues here, like your property, definition of property, we spoke about that yesterday. So one would say we have noted the issues that they've raised and some are in the process of being processed.
Yeah. And I think another thing that they mention is he mentions is the issue of the cost attached if there is a disagreement when going to court, if the government will cover the cost so that where the land is expropriated, that person gets an opportunity to can also defend.
Correct. I think, it has been raised in a number of occasions to say that people don't actually have access to pay for the court proceedings. The state should actually foot that bill. It's one of the proposals that is going to be considered and see how best it finds expression in the bill.
Okay, thank you very much. 37. Oh, sorry, 38. Yeah. 37. Oh, Shamis. Zaron Damon's public wish to register strong objection to the expropriation bill. 38, Hossein Padaki, Best Business Forum. In the chapter 4 of expropriation bill, we find the notice of intention to expropriate, where it states that there will be a compensation offered by the expropriating authority and the owner and the holder of an unregistered right. If the amount of compensation is disputed, a statement that the expropriated owner may institute proceedings in a competent court to dispute the amount of compensation or request that the expropriating authority commence such court proceedings within 180 days of the date of expropriation, which time period may be extended by the court on good cause shown. In the Sowetan 06 June 2023, there was an article, Land Claims Court unhappy with Commissioner as it dismisses Ramrula community's claim. It was about a group of people who claimed they were dispossessed in 1959. The court ordered the claimants to pay for the cost incurred by the landowners on the scale between attorney and client. This includes the cost of 2 counsel and a corresponding attorney were employed. The court also ordered them to pay the fees and expenses of the landowners' expert witnesses. The Ramrula case is happening all over the country where claimants are bullied by highly paid attorneys and lawyers. And lawyers, communities are losing legitimate fights. We are aware that AfriForum Solidarity and their so-called civic organizations have stated that they will tie up these land claims and expropriate attempts in courts for years to come. And we know they have won many cases against government on a range of issues. Are these expropriation attempts just a pipe dream of government while our people will remain landless forever? Will we remain the most unequal country in the world with 3% of have-it-alls and 97% of have-nots, living in informal settlements and suffering in these areas winter after winter? Colonialists come on their ships without land. Today, we are landless and also resourceless because they're also taking our minerals then and now. Okay, if we look at the different land acts of the apartheid era, we know how the white minority were benefiting to the utmost detriment of our people. Okay, and it goes on and on. Section 2 of the bill excludes expropriation, and it says unless expropriating authorities without success attempted to reach an agreement with the owner on reasonable terms, there are limitations on the powers to expropriate, and that all other empowering legislation which allows for expropriation but must follow the procedures contained in the bill, which actually says the expropriation will have a huge fight back awaiting government. The bill says expropriation can essentially be done in 2 instances, namely if the expropriation has to be done for 1, a public purpose or a public interest. This is where the bill talks about the public interest includes the nation's commitment to land reform and to reforms to bring about equitable access to all South Africa's natural resources. We do not believe that if you obtain the land during the apartheid era that you must be compensated according to current market for that property. Are we paying you for benefiting during apartheid and using taxpayers' money where it could have been used on essential services like building hospitals and schools? But now the bill says, no, wait, government will negotiate with you. And if you're not satisfied, we will end up in court for years and government will still lose the case. What about landowners with vast land that are not being utilized? We have thousands and thousands of unused land on the West Coast, and our people need land for housing. After nearly 30 years of democracy, municipalities still push the apartheid special development in our areas. Middleport, Dasville, George, Carriage are far away from the CBD. How is it that we're still struggling after 29 years of democracy with a piece of legislation that should have been tabled in the 1990s? There is an enormous divide between needs of people and the government. Expropriation must comply with the constitutional principles. In the end, it should be considered that the courts will have the final say, especially regarding the determination of compensation for expropriation. The Constitution is a living document and the government has the opportunity to make the necessary changes to benefit the majority. They have missed the bus and now it's going to take years, if ever, to really appropriate for public benefit or public interest. And here we are talking about private land. It is too late to give our people the dignity they deserve when our elders are still on housing waiting lists for up to 30 years and land are unused by private landowners. Let government put action the legislation that is putting forward. We propose that the expropriation bill of 1975 be repealed totally. We support the new expropriation bill that there should be expropriation for public interest and public purpose. We 110% support that there should be expropriation without any compensation. Okay. There's no comment, is what we been hearing. And again, Stanley Lifier, we saw that one, Codesa and Motlanthe. And we go to Patrick Lifier Public. It is 2 from 1. Okay, so it's 39 divided into 2 from Stanley and from Patrick. Patrick says, en in enige grondwetsontwerp deur enige staat enige jaargetal ook al plaasgevind het, sonder die insy van die eerste nasie en 'n wetsontwerp daarop geplaas was, bly dit dan nie ook onwettig te wees nie. Indien enige munisipaliteit en grondbeheer is volgens die Supla-wet of ook Lupa-wet, behoort hierdie wette dan ook as ongeldig verklaar te word nie. En ons as eerste nasie dat grond van ons voorouers van hulle ontneem, was deur die Boerlanders, Britte en die boere apartheidstate, behoort enige ander koloniale wette dan nie ongeldig soos Pluma Act, verklaar Lupa Act word nie. That's the end of the 39. Okay, we go to 40, Ursula Griffiths, no support. 41, Yvette Williams, don't support expropriation bill. 42, Brenda November, don't support. 43, don't support expropriation bill. 44, Elmari Livendal, don't support expropriation bill. Barrett Gali, don't support expropriation bill. 46, don't support expropriation bill from Agatha Erasmus. 47, Winnie from George, she's in support of the bill. Mediation process must be looked at. The 1913 Land Act was forcefully taken. We want a fair process and fully support the initiation of the process to have fair land distribution. Number 48, Mr. K. Lawson from George. Section 12, subsection 3 of the bill provides for nil compensation. This section is in violation of the Constitution of South Africa. 49, Ismail Letsopo, Mossel Bay Development Forum. We are in support of the bill. Once you sell the land, it must be auctioned. The poor can't buy the land. Where is the balance when the poor can't buy the land? Where is the equality in terms of the purchase? Because the poor can't afford the requested amount. I can say, yeah. Okay, 50. Aldred Public Ghana land. I support the bill. The land in the mountain is privately owned. Spa is owned by 3 families. Huh? Okay, these people in Eden don't get a cent for the land. The bill is not to hurt people, but to rectify the fact that land was taken away from the people. We are living at the end of time. The mark of the beast is there. Huh? Why can't we grow food on land that is taken away? Okay. Number 51. Any comment from the members? Members Leku?
No, Chair. I'm just been listening to some of the comments here, and I'm just a little bit worried or getting to the sense whether the people were actually understanding in terms of what the bill is out to achieve, and in terms of public participation, and that is just something that is worrisome, because if one looks in terms of the judgment, in terms of public participation, and one of the issues that were raised was the issue of language and the documentation that was given during our public participation, is that's what we are missing, because it affects mostly people that would find that don't read the kind of language that we speak when we do these public participations. And hence, when you get people talking about title deeds, when people talk about spa ownership, then you actually get a confirmation of saying like, you know, we're not in the same meeting, but we're in the same meeting. You know, it's just something that's my observation, Chair.
Member Mara?
Thank you, Chair. Chair, I think it may be worth noting, but quite obvious as well, is that of course we do note the concerns that may be of a religious mindset, and of course as a committee we note them. We are a province of many different religious groups, and I definitely hear my colleague in terms of the dissemination of that information. I guess it's also it does speak to the procedural aspect of the bill. But on the other hand, I think as lawmakers, what we see a lot of when we go out in public participation is that people also use it as an opportunity to vent and to be heard by government. But that also doesn't detract from the question of have we adequately engaged in public participation? And I feel that's a pertinent question. Thank you.
Chair, I'm going to border on not speaking about legal stuff, but I'm also an official of this institution. And I think the observation that Member Seleko made is a critical one, because you see, Chairperson, the lawmakers are sitting on that side. The quality of a law results from the quality of input and the quality of understanding and participation that we get. We had a very scathing judgment not too long ago from the Constitutional Court in the Mogale case. And I will just positively accept that all members, not these members only, all members are familiar with the particularities of that judgment, because it was an indictment on all legislatures. So I understand, as Member Marius mentioned, that members of the public need to vent. But you see, Chairperson, when we are trying to make a law as profound as the expropriation bill, we are not offering opportunity to vent. We want input in respect of the proposed provisions of the bill. An opportunity to vent. This institution, this creature of democracy, should provide opportunities, platforms, and spaces for the public to vent, but not necessarily during a lawmaking exercise. We have a public education outreach unit. Experienced officials, they get money, the very public's money, and then we get ventilation as part of a lawmaking process. I think we are missing the ball. I may speak out of turn as a lawyer, because it's not my call to talk these things in forums of this nature, but I'm a citizen, I'm an official, I'm also a thinking individual, and I say to myself, somewhere institutionally, we are getting it wrong, and we continue as if the issue doesn't exist, or it will obliterate itself. Naive. So the observation by Member Seleko is a critical one, especially in anticipation of a new term where the quality of lawmaking will depend on the lawmakers with our support. So I would certainly urge the chairperson, at least in the form of a report to the plenary, to call on the institution, mindful of our role as constitutional actors, to call on the institution to interrogate the quality, the extent, and even the nature of public participation, so that we produce quality laws law is a policy statement, and it's only as strong and as meaningful, as purposeful as we will it, as we want it to be. You know, so thank you, Chair.
Thank you, member.
Members, Lagos just opened something that were actually very, very significant. A lot of these things is not about the bill, but it's surely about frustration. That the people has been missed. Now they take this opportunity actually to come and voice their frustration. If you look at the years being dotted down here, 1950 and all those kind of things, how long? I mean, it's nothing to do with us. But in length, we discussed yesterday the role of municipalities. And I think that is where we missed about a bit, that there's no what do we call it now? A role of responsibilities of those people who need to service. And we said it in some of our stuff, is that none of us is better than anybody else. The different spheres of government is all the same, because everybody out there sees you, and then the one who's been left behind or to face the people is the municipality. But they are fighting us, and we are fighting them, and the guy who's getting the short end of the stick doesn't get satisfaction of being a human being, and to be looked after. So maybe when after this has been done, we should come down and get that stick in the hand of government and say, you down there as a municipality will look after the people, because we as a government are taking flick for you guys who's not doing your job properly. It's only my 25 cents.
Mulwin, you, Tashanage, and right. To call. Thanks for this opportunity to talk here. I don't want to go with you on this point that we have discussed. The reason is that we already passed some bill under this situation. I can make an example, the bill for the extending of the members in the chamber. It's passed, it's applied, it's written, but we know ourselves that when they explain, they were talking about work, municipality work, but it passed. We must really not count what they are saying, but we must count what they are voting. Are you agree with the bill or not? If some 8 said agreed, 2 said not, we have to put that point. Because if you go back, you are going to use another lot of money. That tomorrow we said when we want things said there's no money. So we must correctly count, agree or not agree. Otherwise, they can say whatever they want, because people, they are not learn politics. We are not all politicians. So when they are there in the stage, they speak whatever they want to speak, irrespective of what was the case, why they are in the meeting. So that's why those who were wise and can say that they agree, take their points and not agree, because we are going to redo the process and put another point in order for us to delay all these things. This thing I know very well that it's only Western Cape that disagree. Most of them, they agree. So if us now we come to revamp this thing, to want us to be redo, it will cost our time. We must be fairly said that the Western Cape agree or not, because we already have points here. Thank you.
So, okay, I'm going to start with member class. Western Cape, I don't know, government or legislature or communities, because Western Cape, it's the representation of a lot, but the metrics, it's the voices of the people out there. And what we take is, when we formulate the negotiating mandate, we also take the contribution of our communities to formulate our negotiating mandate. Now, when you hear the concern of Member Isaac, is some of the submissions here, they don't give us an indication of how does these individuals that did submission feel about this bill itself. And when we formulate the negotiating mandate, we have to talk to submit to NCOP, what is the community say? Now the question, like Advocate Mazda was talking to, is, do we have enough information? Did we get enough submission to can formulate our negotiating mandate, working towards the final mandate that will really represent the Western Cape communities, not Matlodi, not Class, not Isaac Leku or Kayla, but the communities, because remember, you are a public rep, you are representing those communities, irrespective of the Western Cape, like you mentioned it. It has to be all about the communities. Now, when we started this after this was referred to the committees, we acknowledged that this was going to be the bill that each and every possible, if I think the funds were enough, we would have gone to every town in Western Cape to get the contribution. But because of the financial constraints that was mentioned, we went for the public hearings. And the request was from the committee to the public education, Advocate Master, to go out there to lead the committee, talking to where we are going, for people to know that there is this bill coming. What does it represent? What does it say? How is it going to affect our communities? Our belief was that that happened. And I think I engaged, the committee engaged with the department to give us the report back that they did engage, and the understanding, if I need to be, not to lie, they said to us that no, that we did that. But the unfortunate part is that when we went out, we picked up that that doesn't represent what we were expecting to get from our communities, because now the understanding of the bill itself was not, it's parallel to what we were expecting. So that's the shortcoming when you get the submissions of what we received. And mentioning the issue of the Mohali, and I had a record chat with Mr. Ndu and said that if I had all the powers, this should go to the 7th Parliament, because we are not doing justice in principle. And most of the submissions that we got, that is not submission, the comments was that you haven't reached us, our voices is not in there. Because if I go for a public hearing in Saldanha, a person doesn't have the transport in Matsigama. So that means I left Matsigama, I left Van Rysdorp. So it's a lot of places that I left, people that wanted to do the contribution. And I cannot take the advantage of say, I had the WhatsApp, I had not everybody has got the data for them to be able to do the submission. So that is the challenge that we have. I communicated with NCOP to ask for an extension until February to see if we can be able to touch all those rural areas. And that was, in principle, decently and professionally so refused, and I was given 1 week. If I can add all the professional, because they didn't say no, they said yes, but a week. So that is a decently, professionally, accommodatingly so for a week. which is not possible for us to do that. So I take cognizance of the challenge that we have about this, but this is what we can work with. And I think on our negotiating mandate, the comments that will come up is all this that we are talking about, that there is a challenge of the time is one thing that we were under pressure for the time. And also this is not the true reflection. Maybe I take it that it's not the true reflection because we didn't reach the maximum numbers of people that can contribute or that can do submission to this bill. So that's the challenge that we have. And member class, I see your hand before Mr. Ndu.
Yeah, thanks, Chair. Thanks, Chair. That will be the submission. Saying that, we read all of this thing, and then we, as a department, we saw a critical point that these people, they don't know this thing and they don't understand. They just there. But what others said, because they didn't all say one thing, they are who had agree and disagree according to the readings. So we have to submit and say that as a department, we did put our effort, but we know that there is Matsikama people left. In other words, there are other communities that are left behind because of the strain of money, of we don't know, but it comes from them. But the honest thing is that people, they don't know this thing. They don't know what is happening. But some of them who were there, they are disagree and agreement. Thank you.
With that being said, and Mr. Ndu being covered, I am now on number 53. And 53, it says support the bill. And 54 is Kenneth Hoffman also saying that the Khoi tribes since the beginning of time have occupied the ancestral land. In these territories, our forefathers lived in various kraals, which still bears their names. We all know that the lands were taken by colonialists whose descendants still occupy our lands. Okay. Many of our land parcels were taken and converted into national land parks and forestry. Safco transferred all the Western and the Southern Cape plantations to a private team. My people were totally excluded from all transactions, and our participation was never requested or our consent. Our ancestral land was commercialized and none of our people benefited from this. We request that all our ancestral land be transferred back to our people. See, a lot of our comments, it's more about the land reform, not the expropriation. Okay, so 55 from Peter. He's saying, we are speaking about expropriation. I was a young boy of 4 years old in 1963 when my family was forcefully removed from our farm, which was owned by my father. I promised myself that one day I will go back for my father's farm where most of our people go. Nothing is given back to us. Our land was removed and we don't have money to pay a lawyer to regain our land. I want to ask all these MPs or MPLs to find a way to return our land to us. This is our land. I fought in Angola for this land and my people still have no land. Okay. Next one is 56. 56, public. Didn't give the name, and it says, it talks to section 12, subsection 3. And continues to say, if he doesn't want to sell or get rid of his property, he must have a right to say no. No one must have the right to overthrow the owner's decision. Many people will be happy with monetary compensation, but not everyone. Some people would like to keep their land, and it is their right to keep their land. Esme, Public Caledon. I'm a Khoi woman. The Cape Flats have arrived because there's no work and there's no land to provide housing for the people. We live in flats for years and years. The cockroaches are working because Tom, Dick, and Harry is moving in now. Poor Tom, Dick, and Harry bring cockroaches. Who resides in the Cape Flats is the colored people. How can we trust the government who is not looking out for us? We are indigenous. Our culture has been removed. Why can't we as colored people reclaim our own land? It's land reform again. Miss Mentor, Public from Grabo. I'm standing here as one of the first beneficiaries of land reform in Grabo. Vergelegen Farm was given to 45 people, and at the end of the day, it went back to their mentor and is Vergelegen, which it was before. Protea Farm, where the beneficiaries were forced to take mentors from government and to assist those people. There, the biggest share of the profit goes to the mentor. We must look at land reform correctly because beneficiaries is not actually a beneficiary. I speak from experience. If you look at the maladministration, the corruption, because if I lived in an area for more than 40 years, why is it a beneficiary someone? Why is a beneficiary someone who is from Gauteng? Until these issues are addressed, I cannot support the bill. People, let's do land reform properly, and we cannot support the bill if the land reform is not done correctly. Okay. Land reform. Sanita from Genadendal. I unfortunately can't support this bill. What is deemed by this government as private property? We have a lack of services and a lack of housing, and people on the waiting list for 20 years sitting there waiting for houses. 35% of the community is backyard dwellers. Other people get houses who live in informal settlements. But do we who live in backyards waiting for 20 years don't get houses? If I live on a private property, where is my name on the title deed? Nothing has been transferred to us to indicate that we own property. I'm sorry, I can't support a bill that only has government's expropriation in it. What about the people's expropriation? It's land invasion. Okay, 60, Mr. Donson. And he says all these laws the government put together is all against our people. I'm personally in the fight for the Khoi people. And it talks to 1994. The Griqua leaders went to speak for the Khoi people, and it was said that the Khoi is not recognized. Huh? The UN summoned President Mandela to ask why the Khoi people were not recognized. He then indicated that the Khoi will be included as a recognized people. The Griquas said, we are not the only ones. There are other unrecognized people who have to be included. Why are we only recognized when government requires laws to be passed? Why must we give up our land as the first people? We do not support the bill. So Watson from Caledon, government came with a bill that we are not happy with. People are deprived because of land. If government takes away your property, they are taking away your rights. For this reason, we cannot support this bill. If you vote for this bill, you are hanging yourself. Um, 62, don't worry, remember class, we are going to be here until 6. So continue talking. Mina from Caledon. It is very clear that the Khoi have not been represented clearly and how government is going to return the land to the Khoi people. We have not confidence in this government. It is not clear how this bill is going to assist us. And Cornelius Botha from the Royal House of Khoisan. This is a great opportunity for the Republic of South Africa. Support this bill. Even. This government is giving us an opportunity to access Parliament to have a say. All the Khoi people must put in their claim for the land. They must make sure that they are the ancestors of the original people. If you are not a proper claimant, we can take you to court. You must bring a title deed to prove your inheritance. Land reform. Okay, 64 Maria Africa. I get all and 2004 aansoek gedoen vir huis en gebou, maar elke keer moet ons hoor ons is op 'n waglys. Daar was eers 'n bosbouprojek. Ons was op daai waglys. Toe ons weer gaan moet ons hoor ons op die waglys aan in Hillside project. It's Hillside, né? Yeah. My kids is al 24 and 22 waar hulle klein was toe ons aansoek gedoen het. My kind het RTB opgedoen van in 'n nathok bly. My man se naam is Petros Afrika. Ons wag al 20 jaar vir 'n huis. Kan u ons help? Ons raak oud en ons moet in die koue hok bly wat lek en dit is nat. Okay. 65 Sean Meyer, public, Beaufort West. It is not fair that our land is taken from us without compensation. Section 25 does not make it clear. Property can be anything. It can be the house or the car that I own. There is no clarity that if they want to take our land, then decide what to do with me. There is a lot of land that belongs to the state that the state can utilize. Why does the state want to take our land and use it? The state must first manage its own land prior to wanting our land. The state must just leave our land alone. We owners pay tax for our land. The expropriation bill makes provision for expropriation with compensation, but this is not being done correctly due to corruption. If corruption is rooted out, then expropriation with compensation can be driven properly. They must not be desperate to take our land to use as collateral. For these reasons, I do not agree with this bill, as we as a community must not agree to it. 66, Sarah Lee Zas from Beaufort West. I do not agree with this bill that you want us to agree to. What are we getting out of this session? There's so much that this bill does not cover. The government just wants to take our land. There's nothing in the bill that helps our people with our struggles. We therefore do not support this bill. 67, Estelle van Breda, public, Beaufort West. I do not support this bill. There's no clarity regarding what will be expropriated. This is a violation of our rights that the state can take our land without compensation. We cannot, under any circumstances, come here and take our land and our houses. I therefore do not support this bill. Mario Salsita, number 68, I do not support the bill. 69, Peter Mare. Peter Mare, I want to start with section 1, where property is described or interpreted. If one looks at section 25, property is not defined. So this is a very broad. It's very broad. Are you saying that not only farms and houses can be expropriated, but also shares in a company that has been acquired and the rights in terms of intellectual property can be expropriated? Why don't the government define property so that we can know what property is being referred to? You are now opening the door for the expropriation of all kinds of property. It seems like government is trying to hide something by not defining property. Mr. Ndo, what are you hiding? Okay. Okay, thank you very much. Mr. Ndu is not hiding anything, members. Once the clarity from okay. Okay, public 70 Saldana. My request that this bill be translated into 3 official languages. Yeah. The mic?
Sorry, Chair. I thought perhaps I'm using the host voice. So I'm saying I agree with the proposal that has been indicated here, probably in the coming administration, to say that this issue of public participation, particularly on the basis of the the case laws around its operation, it's not standardized across the country. You'll find that Western Cape do it in a particular way. On the very same bill, you go to Limpopo, they're doing it differently, and also the threshold in terms of the number of people that are supposed to be actually consulted within within a particular ward or within a particular district. Because, for example, I think you're correct. If we have gone to Saldanha, the population of Saldanha is about, in the GI is about 20,000, and we have only consulted 6 or 6 or 100. Is that representative in terms of the issues that we're actually finding on the basis of that? So those are some of the things that perhaps going forward, we need to look into that and see how best we can address that. We agree to say that as it stands, these are the things that we actually get in. But I think, in one way or the other, we can be found wanting, because you might find that the people who did not actually get the opportunity to come have got a different view altogether, and that view is not actually finding expression here. Thank you, Chair.
Thank you. And members Leku and the member class. Must I switch on the clock?
No, Mzuzu.
Okay, go.
No, Chair, honestly, like, it's always, I think before we started as a province on saying that we wanted to cover so many towns so that we can get a view from the Western Cape in terms of this particular bill. But, due to financial constraints, we're able to only do so many. And it also goes back to municipal level. When you do your IDPs, you go to a municipality, or let's go ward base. Your ward has got 2.3 registered voters. 2.3. And then you get to a hall, there's 100 people. There's 100 people, and then you say that's public participation. So, I always find this question, what is sufficient? How can one make a determination that public participation was very sufficient? Now we are talking about the whole province here. It's about 7 point something people. And I can assure you, in terms of comments, it's less than 100,000. It's less than 20,000 comments. It does not even cover a smaller portion of the population of the Western Cape. And one would come to a determination that says, this is the view. I think there's a lot that we still need to do when it comes to public participation. I think there's a lot of experts that have spoken about the quality of public participation, the quality of lawmaking within our country. There's a lot. It's a story for another day. But Chair, thank you very much. 1 minute, thanks.
But honestly, Chair, we must be fair when we discuss this thing. I don't want to mention, but people, they run out of interest in anything that revolves even themselves as a community. Now, we don't have a plan on ourselves to attract these people to come back. Because meetings that were created where we were starting 1994, when they see there's Mandela coming, and then people were always attending this meeting. But after that, they saw things, people say that, hey, if I'm going there, I'm coming from work, and then I must go in to see that people, even that people won't give me anything that can be. So some of other things are created by us. And even we ourselves, we are saying that no matter you vote or not vote, the vote will count. Which means no matter they are 4, it doesn't mean that they can't handle the government. 4 people. Whereas the majority is how, because you know yourself that you can look at that by election and all that stuff. So the meeting that have been come in, and there are people we must appreciate that. Let us take their value for those who are there, and we decide, because we created this thing by ourselves as politicians. We neglected them. Now, when it comes now to, I want just to come to this point of.
Okay. I agree with you that, and disagree with some of the things, but we have to concentrate on this so that we can finish, because we have to have a negotiating mandate today. And what you're talking about is the process itself. And all of you are part of this process. And all those concerns is the voices that I wanted to hear before we go for public hearings, not when I've got the agenda of the matrices and after where you have to formulate the negotiating mandate. So we are going to have time for you to talk about that when we compile the negotiating mandate to raise those concerns, not while we are still doing with the. Can we agree on that one? I'll give you about 2 hours to talk to us about that.
Yeah, no,
When
Chair,
they
only
get
just I wanted to know that no matter how many people are there, let's make a submission. Thank you.
Okay, now the negotiating mandate, we don't even have an option. We have to do that from this representing this legislation. Just for the record, we have more than 7 million community members in this province, and we got individuals about 82 submissions, and then about 8 organizations, if you include 1 municipality. And those are the voices. It's what will be representing the voices of the communities of above 7 million. I'm just putting out there so that.
In conclusion, Chair, remember, if you're a public representative, there's also the flip of the coin to say that you're representing the communities. So the Ward Council, in a number of occasions that were there, I think the issue that we're raising to say that perhaps, coming in the 7th administration, let's look into this matter, we debate it and have a very standardized way of addressing this. From where I'm seated, whatever is captured there, on the basis that councillors were there, and by default, they're representing the community. So therefore, it will be argued otherwise elsewhere to say that, the voice of the entire province was actually heard through the representative, because ours is representative democracy. You elect the people to represent you, and therefore they engage you in the meeting prior to us actually going there. So that's another thing that they tend to actually raise. But be that as it may, it's also open for engagement some other time. Let's proceed.
Yeah, we will proceed because I don't want to debate that part of councillors were there and they were representing you, because it has to be the meeting attached to them before they can come, that they carry the mandate of the meeting that they had before they can come, not individually giving their. So, okay, so we go to, where are we? 67. 71. Okay. And we appreciate you, Couch. Okay, 71 from Saldana. The language of the bill should be plain. We are all not lawyers. Some people know it's an arbitrator and a mediator and what property acts are. Some people from the rural areas do not understand this language. So can you please explain so that this covers us people in the poor areas? In our towns, we have farmers and owners. Some property in those areas are not even registered. Does this bill cover all those people who don't even have a title deed? I think we talked about this also yesterday. Ms. Davids from Saldana, in the year 60-70, there was a farmer who gave his land to the colored people for a funeral. Families of the deceased were not informed that the land was repossessed by other farmers after the farmer's death. Our people were buried there. Can this land be returned to our people? Our parents were not educated. We who stayed behind are not happy with what transpired and want the land returned for us to continue burying our people there. I think 60-70, we have to look at that. I don't think it's 60-70 there. And be another issue. Miss, if you can.
That's what she said.
Okay. Stephen Rose, Saldana, the whole problem with the bill is the name of the bill, expropriation of land. The name alone makes us afraid to delve further into the bill. If we look at section 25, subsection 3, it says without compensation, but the Constitution indicates there must be compensation. 74, Ms. Klassen. Saldana, the bill doesn't speak to farm workers and farm residents that can be evicted from farms at any given moment. Those farm workers have given their all to those farmers. Then you find that some of these farmers own up to 7 farms. One of these farms went and purchased a BEE farm under the disguise of the farm being for the farm workers. When the farm workers found out about this, he ran to his attorneys who are as corrupt as him. The farm workers got the farm at the end of the day, but they did not receive any equipment to farm with. The people can't even get houses on the land because it is private land. No proper housing is allocated. And Jan de Villiers, Member of Parliament, very few people own property. Many people who want property, whether it's a car or a house, they loan money from the bank to buy their property. If you get null compensation from the government for property, that means that you can't pay your loan. If people can't pay their loans, the bank is going to lose. The bank will lose their money if the government starts taking property from people who gave loans on a property. These consequences of taking people's property who have loans will be very serious. National government owns more than 15% of the country's property. Why do they need to take other people's property to do land reform? Any comment? Okay. Bonnie Green, Councillor Saldanha, what privileges are people getting if their property is taken away from them? The bill must make provision for its institutions like SASSA and Home Affairs so that our people can receive better services. Our people have to sleep in the rain to get services. Okay. Breda Valley, I would like, Councillor, there's no name. I would like to know how compensation is determined when the property is in a prime location. I looked through the bill for the definition of prime location of a property. That should be factored into the bill, the concept of prime location. Mini, Councillor in Saldanha. The ANC supports the land expropriation bill. The new bill allows for land to be expropriated with null compensation. This bill prevents the imbalances of the past. Whoever opposes this bill is saying that they are fine with old 1975 expropriation bill. Peter Mare, Saldanha. Land cannot just be appropriated from people. Investors will flee our country. There will be a shortage of food. The government must prevent that. Gerald van Zyl talks to section 25, subsection 2, that alludes to expropriation in subject to compensation. And at the end says this bill cannot be constitutional if it expropriates land without compensation. 81, Winnie Litui Bonge chairperson from NISNA. We as an organization support the bill with the provision that this mediation process must be looked at. The bill must make provision for who must pay for mediation. Take into consideration have-nots. We must take into consideration the 1913 Land Act. When our land was taken from us, it was forcefully taken. It was just removed from us. So we want the government to balance the two. That when this process is done, we are not looking for revenge. We just want a fair process. We fully support your initiative taken for the bill. Without this intervention, we would have had land invasion. Ismail Letoko, Mossel Bay, Public Mossel Bay. I am a chairperson of Mossel Bay Development Forum. I support the bill. I did a course of Desmond Tutu, Reconcile the Reconciliation. How do you reconcile when things are not balanced and are unbalanced? If you look at how the land was taken from the Khoi, our people, and we sit here and say, let us not support the bill, let people be paid. Which Khoisan still own the land in this place today? None. When they sell the land, they say the land must be auctioned. Who still has the money to buy the land? The poor of the poorest don't have the right to receive the land because they don't have money. The rich of the richest, they buy the land because they have the money. They have everything. Now, how are you going to balance the land when the land is being sold for 75 million rand when you don't have money? That land was taken free of charge and other people were killed for that land. Today, you have to pay for land that you have been killed for. Now, the reason for me being here is that we support this bill. I think reconciliation is how it is going to happen so that we and you can greet each other in passing each other on the street. But today we don't look rightly at each other because you have something that belongs to me. I'm sitting at home with nothing. How can we drive to Pretoria when you have a car and petrol and I have to walk on my feet? But you need us to be equal. How are we going to be equal? It is unbalanced. The blacks and colors are oppressed in the Western Cape, and that oppression has to go away. We need our land back. I don't support things that say the public hearing. We need the farms we want to farm as well. The Kwekwe want to hunt because they are used to eating meat. How can they go back to the way that their forefathers have been farming? Only these sections of the bill can help us with that. Thank you very much. Councillor from Mossel Bay, talk to section 12.3 of the expropriation bill allows for expropriation of land without compensation under certain circumstances, and therefore cannot support the bill. 84 Tobisile ANC supports the bill. 85 Stanley Harvey, I support the bill. I'm just glad that after all these years that we are finally taking these steps. My ancestors will be so proud of this moment. 86 from Neville Peterson, communique. Submission talking to section 25. And is requesting as a communique tenant beneficiary, requesting that Provincial Parliament Standing Committee on Infrastructure to hear the appeal once again, to have their submissions tabled before the committee, which was declined and censored in the past. The white settlers in the Union were allowed to govern South Africa with his white-only parliament, and it goes on and talks about the 1924 and talks about the two of the apartheid demos, 1994, that were that area survived Black Liberation 94, the Garden City, and talks to 1928. I'm going down to look at the end, and talks to the section 25 and an appeal to the Western Cape Parliamentary Standing Committee of Infrastructure. The communique tenant beneficiaries are aware that the Democratic Alliance control this committee and that the DA publicly opposed the expropriation of land or property, but the communique tenants committee is aware that it is being used as a case study.
Chairperson, away from this committee, I think if we look at, isn't it the first communique thing that we had, and we look at what we had when we were sitting here with our public hearing, there must be somewhere outside this where we can just maybe look at this as a unbefuling to somebody to look at these people, because you can see there's a big frustration in that area in Cape Town. Just make a mental note of it, not for this purpose, please.
Yeah, I think it is noted, member, but I think it's more of if we will talk to the rental tribunal to check the cases that they do from the Department of Infrastructure.
Good.
To check the cases that they do have from communique and look at the types of the cases that they do have, and we'll take it from there. A little bit of taking in already. We've got, it's not, we had them the last term communique and the year before that, but it's more of the landowner and the tenant that always they don't agree with each other. And at the end, the diagnostic assessment was that they are steadfast in saying that I've been living in this place for about 15 years. I want the title deed. Now they look at that There are houses that post 1994, people have been living in that, and eventually the Department of Human Settlement transferred those houses to people that were staying in those houses. And they believe that also from communicate side, that has to the rentals that they've said, that has to happen, that because I'm staying for 15 years, I have, and now this is you find is a private land. Those that were transferred were government properties. It's not the private owned, like they communicate that those is not the government, it's a private company that owns the land. So those dynamics is what it is. So if we have to look at the relationship between the land, the property owner and the tenant, it's where we can go to infrastructure for them to come and brief us and say where the relationship between and communicate, how is communicate handling the relationship with their tenants and what are the issues there, rather than going to that, because sometimes we get to, in a way, raise expectations, and we find that we need to get the background information before we can interact with the tenants and cause more damage rather than when we're thinking we'll create harmony between the two. Thank you very much. And let's continue with the Cape Town. Again, it's section 25 2B that is mentioned by public Cape Town. It doesn't say the name. And I'm going to go at the end. And it talks about the expropriated authorities will reach agreement is one of the things that has been highlighted again and again of if there's no agreement. And the bill is making the public, the bill is making it very confusing to some expropriating authority. Basically, anyone can be an expropriating authority. And no one knows if the president is on the list or the premier is on the list. Anyone can take your stuff as if they are in the government. Well, not anyone, but the official does not know who is on the list or not on the list. So broad is the list. And if someone is on the list, is confused, and they think that they can take your land first and go to court afterwards, it seems very much that this bill is going to help them and it's going to help the people of South Africa. Ms. Andu, you want to?
See, I think again it boils down to the issue that the honourable member has actually raised. Because if you check the bill in terms of expropriating authorities and an organ of state, it's very explicit. If your pieces of legislation does not actually allow you to, so you can't. So it's there, and yes, it's true. That's lack of understanding in terms of how we've actually flagged it in the bill. But be that as it may, we have noted the concern that have been raised. It's a question of entrenching and making them understand.
Yeah. Okay. Thank you very much. And 88, Kenneth Matlo, a member of Housing Assembly, grassroots community-based organization. They, in summary, they welcome the bill, but they cannot separate the issue of housing and land. Many are getting evicted from social housing. Again, it's the rentals. In areas with first-class amenities like the city center. On the other hand, most BNG and RDP, even temporary relocation areas, are built on the periphery of the city. The bill must especially include or make reference to spaces close to the city center. Also, in terms of limitations of the rights, Section 36 of the Constitution must then apply heavily when it comes to points of compensation and market value, because it would do no good if land is expropriated on one side and then taken away through evictions and market inflations that render people unable to keep up with their rent. Therefore, any discussion on land expropriation must consider and include Section 26 of the Constitution. Land and housing must be addressed as a cause and effect scenario. And we feel that too much powers are given to the minister. We feel that the minister is based on the basis that they represent a particular political party in their position. Since 195 of the Constitution talks about the needs of people that may be responded to. people need to participate in policy making. Create a joint committee that will involve the minister, involve community residents, that will involve civic representation instead of expropriating powers going directly to the minister. The bill that was presented today was not delivered in the various languages. Also, the legal jargon that was used in a language that was directed to us, the people on the ground who do not understand, make sure that we understand the bill is in a language we understand. Okay, there has been talked to Susanna Coleman, the PHA, there's the Philippi. Suppose the bill is proposed, we'd like to thank the committee for the work that they have done to make the contents of the bill accessible and understandable. The PHA campaign represents a large number of landless farmers and farm workers who believe that the land in farming areas should be productive and not be kept followed by developers who are trying to make a profit out of the land. And that is covered by one of the clauses in your bill. We also believe that the concept of a just administration action with regards to expropriation procedures will more than adequately cover the concept of null compensation is just an equitable compensation given the history of this country. Thank you for your team who has just made this available to us, and we support the expropriation bill wholeheartedly. Patrick Musukwana of Khayelitsha said we need land to progress. I support the bill, and that was the last submission, which is number 90. And so what's going to happen from now is we can listen to Mr. Ndu, maybe summarizing, because we are done with you for the day. And it will be after the body break for about 15 minutes. Then we come back for the submissions of the negotiating mandates, the issues from the members, and yeah, there's tea and coffee for all of us. And then after that, we will break again for allowing the procedural officer, the senior procedural officer, to compile all the submissions from the members to check everything. And then we will take it from there. I think the three of you, if there's any comment, starting with Mr. Ndu.
Chairperson, I think, so far so good from me. There's no comment that I could actually raise, except to say that one would actually be very interested in terms of the mandate that you're going to actually come with, which is going to be presented on the 24th. Others have actually presented, because once they present, the questions that are actually coming from your negotiating mandate, as a department, we look into that, preparing, in preparation of the 24th. Because we'll be expected as well to actually give some dimension as per questions that are actually emanating from there. But remember, I've reflected to say that this bill is in the hands of Parliament now, and most of the suggestions that we're actually making as a department, in one way or the other, they don't actually find expression on the basis that they said you have drafted the bill, you presented it to us, so we're looking into it. It's like an oversight that you're actually playing on the draft that we've actually given. So from your side, members of the committee, feel free to actually make it a point that all the issues that we've actually spoken about, to say that they're not clear in the bill itself, you flag them, and the proposal as well in the process, because at times when you say it's not clear here and you're not offering, I think that's what you're not offering some suggestion in terms of what we need to look into to tighten it a bit and to speak to the needs of our people. It doesn't actually give us a clear picture. We'll then actually battle, because remember, we've sponsored the draft, and therefore that's how our thinking actually ends by then when we're crafting the bill. So you are the lawmakers, you might actually find a lot of loopholes. You have to actually tighten those loopholes and make suggestions. And we look into that, and they give us guidance in a way. Thanks, Chair. I think.
Thank you. Pamela.
For me, firstly, just wanted to thank you for allowing us to be in this process and making it comfortable, because it is nerve-wracking at some time. So I think it's my second one since the Housing Consumer Bill one, but I just want to echo the thinking around what to do differently in future. I think it's clear that expropriation invokes certain images and views and feelings for people. And perhaps it could have been anticipated that it would lead to a lot of confusion because clearly in the submissions, people submitted restitution claims and all these kinds of things, and they keep on coming up. There's housing issues, there's rental issues, as you can imagine, and they are all somehow linked to the idea around land and acquiring and property and all of that. So those things perhaps could have been anticipated and clarified, and softened the language in some parts, but it's been quite a very interesting process, and I wish everyone involved well.
Mr. Das? Mr.
Nothing
Diaz?
from my side, Chair.
Okay, any comment? No comment.
Nothing from my side, Chair.
Okay. Advocate Mars Dorp is going to be with us, so he's still stuck with us until we finish with our negotiating mandate. But I just want to say thank you. Maybe if I can allow Member Slake to thank the Department of Infrastructure National on our committee's behalf for being with us. Over to you, sir.
Thank you very much, Chair. On behalf of the chairperson of the Standing Committee of Infrastructure in the Western Cape and the members and the officials of the Western Cape, to the department, National Department, thank you for your presence since we started this process and for the last 2 days. And all I can say is that we wish you all the best. May you have a safe flight, have a blessed festive season, and a prosperous 2024. 2024 is going to be a great, great year. Thank you very much.
Thank you very much, Ms. Pamela. You are stuck with us throughout until next year. So maybe we might need you when we finalize our housing protection consumer bill. We will communicate with you. We're still waiting for the D bill. And Mr. Ndu, thank you very much. And there is a coffee if you're going to. Thank you very much. If you can drink coffee before you go. Members, ladies and gentlemen, we'll come back 11:30. And can I adjourn, Mr. Diaz? Thank you very much. I don't know if you're going to. We also want to thank you for being with us up to now, and have a fantastic day further.
Thank you very much, Chair.
Okay, thank you. And with the metrics of the comments for the public hearing, the expropriation bill, we are at a stage now that we have to formulate our negotiating mandate that is due tomorrow. So I am going to allow, must I allow Lizette? How are we going to go about this? Just to brief some of the members maybe that don't know how the process forward, that when we say negotiating mandate, what does it mean and how can we go about?
Good day, Chairperson, good day, members. So we've started with the sort of consideration of the submissions on the bill, which the committee did yesterday and today. We're now entering the negotiating mandate stage, which means we are now submitting the report on the negotiating parameters on what we propose as amendments according to the input given during submissions, or what we agree with. But I think if I speak about previous negotiating mandates, I think now is the time where the committee members must actually give their thoughts on the input, whether we agree with the proposed amendments by all the submissions, which is WCG, AfriForum, oral written submissions, and then just give our way forward in terms of drafting a mandate report for NCOP.
Thank you very much. Members, any question before we start? Okay. Let's start now. I'm going to give an opportunity. Where's my pen? Okay, I'm going to start with Member Mare.
Thank you, Chair. Chair, I think in looking at the negotiating mandate, there are some themes that become apparent to me and that I think could guide us possibly as a standing committee. But first and foremost, I think we've seen today and we've seen throughout the course of the public hearings that there are a number of concerns, substantive as well as procedural, when it comes to the expropriation bill. And I think this is very alarming, particularly in the discussion around meaningful land reform. We can't be engaging in land reform for the sake of land reform that doesn't result in anything that will actually benefit and improve those most impoverished in our communities. But we need to be putting forward legislation as our responsibility as lawmakers that actually makes a difference. And so that's why, Chair, before I just delve into these themes, I think from the outset, I would not support this bill, and I would not confer responsibility to the NCOP to support the bill. I think for me, the first theme that comes out of the engagements from today and through our public participation process is inadequate just administration and considerations around public interest. So I think that was definitely a theme that came out of our discussions today. How far has awareness and communication around this bill gone to? We've seen this in that a lot of the feedback that we've gotten on the reports doesn't actually speak to the bill. But also, if we look at the processes that are followed in other spheres of government, are we really satisfied that every single measure was taken to really get the message out there so that members of the community knew the bill that was before them? I'm also, Chair, as a second definition, I'm concerned, deeply concerned about the broad definition of property and the scope of expropriation. I understand that it aims to adopt the Constitution's definition, but this does leave the door open for a lot of things that might concern us. How far are we going in terms of expropriating property? And I say this, Chair, because if the purpose of the bill is to institute meaningful land reform, why then do we need to expand it to other forms of property? So, Chair, that is something that a theme I feel quite important to raise in our negotiating mandate. We've spoken before about procedural steps or ambiguous compensation. This is another theme for me. So what I would say here is that the expropriation procedure that has been outlined in the bill, while it does seem comprehensive, it does lack criteria for me in terms of valuations, and the subjective market price, and potentially opens the door for unjust compensation. There also seems to be an absence of clear benchmarks for market values versus municipal values, which could lead to arbitrary or inequitable compensation that undermines property rights fundamentally. I think there are substantial questions and concerns that I feel still are not answered, and these come from the bill. In particular, as I mentioned before, how will property be defined? Can it be defined more narrowly to prevent arbitrary expropriation? What assurance is there that representation by affected parties will meaningfully influence decisions, i.e., if you own a piece of property or you've gone out of your way to take out a bond for that property, it's then decided that that land will be expropriated. Do you truly have a say in terms of whether or not that property is expropriated? Because at this point, I still think it's a bit arbitrary. Chair, and then the other substantial question I think is unanswered is how will the bill prioritize the urgent need for land reform and housing rather than allowing expropriation for other purposes? Another theme for me, Chair, is legal and administrative implications. So the bill's interaction with other laws and other administrative processes, particularly around the title deeds office and also around traditional land ownership, seems unclear, and it could also have unintended disruptive consequences. And then nil compensation and risk to private property. Chair, the nil compensation, I understand that the Constitution does currently allow for it, but it relates to land. And I also feel that this could undermine the entire concept of private property as it's understood in South Africa. So without any exhaustive checks, this could lead to widespread expropriation, fostering or ultimately acting against the desire of the bill to create genuine land reform. So with that, Chair, I think the bill in its current form is flawed. I think it could jeopardize property rights for all South Africans, and it could deter investment as well as stifle economic growth in our country, as well as our province. I don't think it will intend its purpose of meaningful land reform. I actually think it could hinder it. The bill also needs substantial revision in order to create meaningful land reform. And that's why, Chair, my recommendation would be to this committee and yourself that we do not accept it. It does need to be thoroughly redrafted if it should serve the purpose of land reform, meaningful land reform. And I do not think we should confer an obligation or duty, apologies, my English is running out, to our NCOP delegate to support the bill. Thank you, Chair.
Thank you very much, Honorable Mari. Member Peter de Villiers.
Yeah, there's a lot of things that we went through the period that I'm with you. I came a bit late, but I caught up quite well. There's a lot of things that can distract us. That can take your mind away from the actual thing. From my side, it's not about supporting the bill or not supporting the bill. If we look at the bigger picture here, it's about what can we introduce into the bill that can make a meaningful a contribution to the lives of the people who got us there. That's what it's all about for me. So okay, if I can take it a bit back to rugby, a lot of people say you need plan A and plan B to play a rugby game. For me, there's only one plan. You can't, with the talent that you do have, you can't play 6, 7 plans. It will go to waste. But in that plan, there's a hell of a lot of patterns that you can use. And I want us to use the patterns to put our mind to it. The plan is the bill. We're going to be outnumbered by all the other provinces. End of story. So if we go in with we not support and all those kind of things, we might just miss the opportunity to constructively change what we can, rather to eliminate ourselves from it. We don't need to say we support, or we don't need to say what we support. We can only focus on the patterns in the thing, what we would love to see in the as a meaningful difference for whatever we went through. So if I can ever say today is that don't let us get distracted by the little things, but let us set our mind on the stuff that we can actually control. To if it goes through, we are still in control of the thing. If it doesn't go through, we are still in control of the thing. Ending it off, I want us to control this game with the ball in our hand and still control it without the ball in our hand. Thank you.
Thank you very much. And another thing maybe is that the most important thing for now is so negotiating mandate is more of trying to have an influence into the bill itself, not at the stage of whether we support, but it can be you mention it, whether you support or don't support because of the amendments that you want to see into the bill itself. So that's the issue where we are now. We are trying to develop something that we want to influence the bill, whether for each to, if it goes through, that we contributed in tweaking some of the clauses to really make sense to our communities, or to showcase with our negotiating mandate some clauses that are redundant. They are not needed there because the interpretation can be what the intention is about the bill. So it's negotiating mandate is where we are trying to play the chess to have an influence for the bill itself. Yeah. Member class, do you have contribution?
Thank you, Chair. First of all, if you can say me, I can say I don't support, if you ask me. The reason for me not supporting nil compensation, what does it mean, nil compensation? When they explain it's zero compensation, which means if it's zero, it means that it's supposed to be something in because it's zero. Two, their process is not thorough, is not a process that we expect for them that people will know. It's not been known. It's just a process that people, that the government want to do. But before they table in a parliament or whatsoever, they didn't sit and give the resolution. Only they just tell people that it will be nil. My worry is that, did they mention which land are they going to occupy? Which land are going to occupy? Because it's a private land, it's a government land, and it's also other countries that owing land. You see, there's three different sectors: private, government, and then make an example. We were in that place. They show us that is owned by the church. What they are saying on that to this thing. So that is why I said they didn't specify for us how they're going to occupy, which land that they are going to occupy. And we are a government ourselves as a province. They didn't sit us, they just give us an assignment. Go and tell people. Go and say people there is a expropriation of land. They were supposed first as a government, before they supposed to send their technician, people who've got the knowledge of this thing, and put us also on the ground, because what's bother us is that when we are sitting in front of the people, we are just listening because we don't know this is what they are saying. Even those who are explaining, I see them that they are just reading. Why I'm saying this are reading? Because they don't give us information where we said clap hands. We are just looking at them and said, but the most important things that I can mention, they didn't. I don't agree with the nil conversation. Two, I'm not supporting, or I don't know which land they are talking about, because the land is divided into 3 spheres, which I know, private and also government land, because the province also has a land, and lastly, the land that is owned by overseas people. So we don't know that. So even when they are talking about expropriation of land, there is a land where there is mine, Mkoti, where there is a gold. So if they took that land, they took that mine. Did they specify which land they are talking about? No. That is why they must specify everything correctly in order for us to be fair to the people. That is why I didn't bring some people to them, because I'm just wasting people's time. The last thing I can say with this expropriation, please, let us make our own plan if they come again. How because what is needed now is to revisit the community. Because we also mentioned that they don't know, these people, they don't know what. So what is needed is to visit the community and ask ourselves, when we say to them, we submit revisiting, we must also, Tina, have a plan of ourselves, saying that if we're going to Matsikama, we're going to this place, what is needed? How would we get people to be in the meeting? All that stuff. Thank you.
Thank you very much, Member Sleko.
No, thank you very much, Chair. Now, Chair, I want to do justice if I'll have to talk to all the to all the comments because of amendments. Because if you look at all the amendments from the individuals and from the private, from the annexures A to G, you'll find there is a lot of unclear clauses within this particular bill that we're not able to get an answer from the department. And I will just mention one, and I think one clause that has been having a lot of uncertainties is clause 12. So if you go to clause 12, you would hear a lot of things where they mention reasons as to why one would compensate, and the question is, what other reasons is there that is not mentioned? And also there is also a little bit uncomfortability in terms of the role of the minister, who's being given the the go ahead to expropriate, even land that belongs to municipalities, and what role is the municipality also going to play in that regard? And also one would have to also look in terms of the duty that the municipality needs to, if the municipality does not notify, that there's arrears, who bears the brunt, what measures are going to be put in place, because if the municipal manager neglects his responsibility, and then it might delay. And also in terms of the delay of the compensation, if the payment takes longer, is there going to be interest added? Is the person that is going to get the money going to get interest, because of the delay of the transaction? And also the issue of litigation has been coming up very, very, very strong, because we don't even know who is going to foot this bill, and then, and who is going to be responsible, and all those kind of things. There's a lot of questions, Chair. And I think when since these questions are not been able to be answered by the department or commitment given to us, that we will look at this amendment so that this bill can be made workable. And lastly, Chair, the issue of public participation, which I strongly feel, is that when the presenter of this particular bill, which is because this bill is a national bill, and there were, because when you look at us as the Western Cape, the majority of people here are Afrikaans-speaking people. But when you look in terms of the number of submissions, you'll find the majority of submission has been written in English. And that's why you get a sense of that the comments that you're currently getting might not speak to what we want to hear, because the presentation that was not done in the language of the individuals, and the language that was shared, or the language of the presentation, was not a language that is understandable or is understood by the majority of people that must actually comment on this particular bill. So those are just of the issues, and I think the issue of time frame that we've also asked that we get an extension from the NCOP so that we can also cover other areas, so that we can get to the port, so that we can get more views that represent the views of the Western Cape. So Chair, with all of those issues and unclear answers and the suggestion from the comments that some of the clauses must be rewritten, must be rephrased, I don't think one would be able to, give a mandate that says we support the bill as in its current form. I think when we'll have to consider our final negotiating mandate, then maybe we'll see what the department has responded to and whether all of our concern has been addressed. So at this particular moment, I'm not at ease to say we can support the bill as it is. Let it go to the NCOP. Let's see how they go about looking at the concerns that has been raised by some of us, and then we'll take it from there. But at this moment, I cannot support the bill as it is. Thank you, Chair.
Thank you very much. I think I'll just take a lead to make it easier for the procedural staff to get the negotiating mandate in order. Like I mentioned that, for now we are at the stage where we want to put an influence to the bill itself about what we mentioned. So if you mention like your litigation is which clause and what is your suggestion about that, that's where you have to indicate, because before we come with a final mandate, they would have responded to the suggestion that we have. So I do have a document that I can use that it's about 12 pages. So maybe what I need to do is, okay, let me start this way. From my side, it will be first, the definition of court that is makes to be mentioned in the subclause C to intangible property. So there are a number of considerations around intangible property that would require its own specific guidelines for expropriation. So therefore, we suggest that either additional guidelines are brought into the bill to deal with this, or that the definition of property be amended to exclude intangible property, which is the proposal that we'll put through. The definition of disputing party includes an owner, mortgagee holder.
Chairman, sorry to interrupt you. I value your input so much.
Yeah.
You just mentioned there's something about the 12-page something. Is there any way that we can get it in a hard copy to have something in front of us to work from?
Okay, so this is my way. So they're taking that, and after we're going to break for an hour or two, then they're going to compile everything, and it will be in front of you after that. So for now, it's for them to get which are the clauses and how do I propose that we send that negotiating mandate, and then
Thank you.
after you'll have that copy, and also what member Mari has also thrown in from herself. And the comments, also the comments that you made, also they will be included. Okay, no, thank you very much. Okay, so the disputing party includes an owner, mortgagee, holder of the right contemplated in section 20, expropriated owner or expropriated holder who rejects the expropriating authority's offer of the compensation. So I disagree with the removal of counter offer in final version of the bill. And the holder of the right means the holder of an unregistered right in property, but exclude an unregistered owner is one of the things that were there also. They suggested that this definition should also include a registered right in the bill. Expropriation means the compulsory acquisition of property for a public purpose or in public interest by an expropriating authority or an organ of state upon request to an expropriating authority. And expropriate has a corresponding meaning, which the definition should include curtailment of rights such as inability to use a property for business purposes. It remains unclear if the definition includes temporary expropriation. The other one is the valuer, means a person who is suitably qualified to value particular property, and includes a person registered as a professional valuer or professional associated valuer in terms of the Section 19 of the Property Valuers Profession Act 2000, is Act No. 47 of 2000, are meant to make less vague, particularly in respect of suitably qualified. So that's another one. Now, clause 3 to amend is, clause 3 subsection 3 is redundant as it will be covered by clause 3 subsection 2. Furthermore, it is contrary to the purpose of the bill as it does not directly relate to a public purpose or public interest. If such expropriation examples were to meet to the requirement of public purpose or public interest, this subsection would be redundant. The clause 3, subsection 5A, when the minister expropriates property in terms of the subsection 2, A, the ownership of the property vests in the relevant organ of state on the date of expropriation. The amendment will be payment of compensation should be a prerequisite for vesting. The clause 5, subsection 1, the amendment, land is an emotive issue and subjective factors, that is the motivation for the amendment. And land is an emotive issue and subjective factors can come into play when determining its value, particularly when an owner is being forced to give up their land under an expropriation situation. And we would like consideration to be paid to subjective elements, including financial, sentimental value, rather than a purely objective assessment. Other considerations include the cost of relocating and other costs associated with leaving the property. It is suggested a clause similar to what existed within the preceding Expropriation Act, Roman figure 2, an amount to make good any actual financial loss by the expropriation should be included. That is the amendment on the clause 5, subsection 1. So to put that on the Roman figure 2 and say an amount to make good any actual financial loss by the expropriation. This consideration can either be included in this clause or alternatively in clause 12. So either or between the two. The clause 5, subsection 5, it is recommended that longer time frames be included throughout the bill that are more realistic than the commonly referenced 20-day period for a matter as important as expropriation of property. Significant time should be given to all parties to ensure compliance with detailed requirements. One of the issues that was highlighted is the issue of the communication, where the land has to be expropriation. And one of the suggestions, I think, from the Western Cape government was it's better maybe to use the sheriff. If it was the government, I don't know which one contributed to that. They would say better to use the sheriff because the bill itself is still talking about the facts. And so, and you can't say the email also it can be, but not everybody has got the email or any other form of communication. But the sheriff will make sure that where the expropriation is going to happen, that person has got the communication. Then that will justify the time frames when coming to that happening. And there will be a proof of the person received the communication to that effect. And clause 5, subsection 7, if the property in question is damaged through an act contemplated in subsection 2, an affected person may deliver written demand to the expropriating authority. An expropriating authority must repair the damage to a reasonable standard or compensate for the damage without undue delay. Amendment is greater specificity is required with respect to who determines the standard of damage and the quantum of damages. It is suggested that a baseline assessment of the property be conducted prior to any work performed so that an objective assessment and the extent of the damage can be conducted. This will protect both the state and the owner. A reasonable standard is also not sufficient. Like in the bill, they say reasonable standard. It's also not sufficient. Any damage should be repaired as close to the original state as possible, or sufficient compensation be provided to restore all damage. Furthermore, damage should not be limited to just tangible property. The damage should refer to damage incurred by the owner, which could include negative impacts on livestock, or ability to farm examples. So the idea is that there need to be inspection of the property before, so that if we talk about the damage, there is we've got a clue, the government has got the clue of how did it look before. And then we can go to if there need to be the compensation for the damage, there is a standard of how it looked before the damage. So that has to be taken into consideration. And the clause 6, subsection 3, the municipal manager must deliver a written response to the request contemplated in subsection 1 within 20 days of receipt or within a reasonable time to be agreed between the expropriating authority and municipal manager. There are no clear consequences outlined should a municipal manager fail to adhere to this time frame. Given the non-compliance may result in a material delay in the expropriation process, clear consequences and remedies should be outlined. So that is another thing that was mentioned yesterday was the issue of the powers that are invested in the MM to be the one. It should be, we are meant to say the council, the municipal council, because much as the MM is the accounting authority, but the council is the one that has to empower the MM to implement. Are we in does it make sense in there? Okay. And here but this clause it's talking now to the time frames, because not all municipalities operate in the same way. You might be let's say council have empowered the MM, but the MM takes its time to respond to the expropriating authority. So there need to be consequences of when that doesn't happen, then what? Okay, so clause 7, subsection 2, H, I, and H, Roman figure 1 and Roman figure 2. Minus, okay, let me say this. The clause 7, subsection 2. Somewhere it says a notice of intention to expropriate must include, on H, it says, an invitation to any person who may be affected by the intended expropriation to lodge with the expropriating authority at a given address within 30 days after the publication of the said notice, subject to section 25, Roman figure 1, any objection to the intended expropriation, 2, any submissions relating to the intended expropriation. So this is unclear that these objections are given any weighting or if they must merely be considered. There is a need for the objections and submissions made in those clauses to be considered and for them to potentially have a material impact upon the final decision to expropriate. This is currently not provided for. So we suggest that these provisions instead form part of the investigation phase, as this will have more impact and weight in this phase of the process. This clause 7, subsection 3, if the property contemplated in subsection 1 is land, the expropriating authority must also deliver a copy of the notice referred to in subsection 1 to. There are, and then it continues. So the comment is that there are specific requirements for expropriations involving land, including to send the copy of the notice of intention to expropriate to additional government departments. However, for other types of property, no such additional requirements are present. This should be considered. Now, the clause 9, date of vesting of property should be upon payment and not just the date of expropriation. The clause 12 of the bill, which deals with the determination of compensation, subsection 1, I think member, I'll skip that one because member Isaac talked to that. And I'm going to leave the section. I will share with the procedural officers my comments on the section 12 in detail of the clauses that and then we'll see them in our negotiating mandate. So on clause, the next one, it will be the clause 14, subsection 1. The owner, mortgagee, and holder of a right may request the expropriating authority in writing to provide reasonable particulars about the offer of compensation or the counter offer as applicable, and particulars so requested must be furnished within 20 days of such requests. 2, if the expropriating authority fails to provide the requested particulars, the person making such a request in terms of subsection 1 may, on notice, apply to a court for an order directing the expropriating authority to comply with subsection 1, and the court may make such an order. 3, an offer of just and equitable compensation and a counter offer remains in force until A, revised by the expropriating authority, B, the amount of compensation has been agreed upon, or C, the compensation has been decided or approved by a court. We disagree with the removal of the counteroffer references, that greater support should be provided to the claimant in making such requests. At present, a court order is required by the claimant to force the expropriating authority to comply. This is costly for an individual, and other more affordable mechanisms to enforce compliance should be available. This talks to the issue that has been raised and said, in saying who will be responsible for the court fees. If you are going, the government is going to expropriate my property, and I don't agree with the compensation amount. If I have to go to court now, who's going to be responsible for those court fees? Clause 15, subsection 3, any delay in payment of compensation to the expropriated owner or expropriated holder by virtue of subsection 2 or any other dispute arising will not prevent the passing of the right to possession to the expropriating authority in terms of section 9, subsection 2 or 4, unless a court orders otherwise. The clause 15.3, it's a bit problematic. This expropriating authority could delay the process, which may unfairly prejudice the owner, with possession passing without consensus on compensation. This clause is therefore heavily weighted in favor of the state. So the state can just expropriate and ownership be taken while you're still arguing the compensation amount. So it's in favor of state or not the holder of the property that has to be expropriated. So it's a bit sounding unfair on that. And then the clause 16, subsection 1. Now, if the property in terms of this act was immediately prior to the date of expropriation encumbered by a registered mortgage or subject to a deed of sale, the expropriating authority may not pay out any portion of the compensation money except to such person and on such terms as may have been agreed upon between the expropriated owner or expropriated holder and the mortgagee or buyer concerned. As the case may be, after the claimant has notified the expropriating authority of the agreement. So there's no guarantee that the mortgage will be settled. And we talked about this. This is another concern. And scenario could exist where the compensation paid is insufficient to cover your mortgage. So, or insufficient to extinguish the debt on the mortgage, which leaves no compensation for the owner of the property. Banks also wield more financial power than owners, and as such could ensure they secure their portion before the balance is allocated to the owners. This could see owners left with nothing while the banks have had their debts settled. That is one of the concerns of it's silent on the scenario where you are expropriated on the property that is attached to your bond. The clause 17, subsection 4C, despite provisions of any other law, the expropriated owner remains liable to the municipality for rates and other charges levied on the property until the right to possession vests in the expropriating authority in terms of section 8, subsection 3F or section 9, subsection 4. That clause we oppose if the date of possession is later than the expropriation date, the municipality may hold the former owner responsible for municipal costs. This clause is patently unfair. So maybe it could be amended to read, or the ownership passes to the expropriation authority, whichever occurs first. So that is the inserted clause that we will propose on that, on the clause 17, subsection 4C. Okay, and on the clause 19, subsection 8, any appeal against the decision of a court on the amount of compensation will not prevent the expropriating authority from expropriating for the amount approved or decided unless a court grants an interim interdict based on compelling prospects of success on appeal. Again, we oppose this clause as any dispute or lack of finality relating to compensation should hold the expropriation process until it's finalized. And on 20 subsection 9, an expropriating authority may at any time during the temporary use of the property commence with the expropriation of the property and must comply with all relevant provisions of this act. This also, we oppose that. If the expropriating authority determines that it wants to proceed with a permanent expropriation, this process should begin anew once the possession has been restored. Otherwise, this will unfairly prejudice the owner and place the state in a superior bargaining position. And when property is taken for a temporary use, there is a realistic expectation that it will be returned. And government should not be allowed to negotiate from a position of already being in possession of the property, because this talks to, it can be a temporary expropriation. That means it's not permanent. So go to Isaac, temporary expropriation. Isaac moves to go to a rental, maybe it's a permanent residence. And after they say, okay, now we continuously temporarily expropriate, we can negotiate. So that it will be already they've got all the foot in, you outside, and negotiate at a disadvantage because already in principle they've expropriated you. That makes you of the government to be in a position that you can negotiate. The 20 subsection 10, if the property in question is damaged as a result of the performance of an act contemplated in subsection 1, the expropriating authority must repair to a reasonable standard or compensate the affected person for that damage after delivery of a written demand by the affected person without undue delay. Now, I think I already talked to that one. The great specificity is required in respect of who determines the standard. Is the issue of who determines the standard of damage and the quantum of the damages. We will be responsible to do that. The clause 21, subsection 1A, it says, notwithstanding anything to the contrary contained in any law, the expropriating authority may withdraw any expropriation from a date mentioned in a notice of withdrawal if the withdrawal of that expropriation is in the public interest or the reason for which the property was expropriated is no longer applicable. It goes to the public interest. It's too vague for this section. The purpose for a withdrawal must be extremely important. And there should be a very limited list of specific circumstances in which withdrawal can happen. The inclusion of this clause supports the need to have a very thorough process of investigation at the outset in order to ensure that there are no mistakes made later that are difficult to rectify. Okay, is that clear, Nick? Okay. Clause 21, subsection 3, and it says, if an expropriation of property is withdrawn, A, ownership of the property concerned against vests from the date contemplated in subsection 1, in the owner from whom it was expropriated and any mortgage or other rights discharged or expropriated in connection with or as a consequence of the expropriation are fully revived. The registrar of this or the registrar of any other office at which such expropriated right was registered or recorded must, on receipt of a copy of the notice of withdrawal, cancel any endorsement made in connection with the expropriation in his or her registers and on the title deed in question. And C, the expropriating authority is liable for all reasonable costs and damages incurred or suffered by a claimant as a result of such withdrawal. So the 21 subsection 3A appears to be a contradiction of subsection 2B, which states that where the expropriated property is lent, the property has already been registered in the name of the expropriating authority, ownership only takes effect when property is registered. So subsection 2B applies and this clause is superfluous. So I think this subsection should be removed and that subsection 3B and C can be retained. And now it will go back to the issue of what effect does it have to the whole bill itself, if that is being removed. But for now, it's negotiating mandate. We'll put it in there and then we'll hear the responses. And furthermore, the mortgage would have been paid off and the account closed with the expropriation. So it cannot just be revived. It will be a new application and in all probability at the prevailing market price, which would be different to the original mortgage. This would be extremely prejudicial to the owner who might have paid a far lower mortgage price for many years and who now has a new mortgage with their new terms and conditions. Okay, and clause 22, subsection 3. It says whenever a document must or may be delivered in terms of this act, it must take place by delivering to the owner and holder of an unregistered right in a property known to the expropriating authority at the address appointed in the notice in terms of section 7, subsection 1. The notice of expropriation, the notice in terms of section 11, subsection 2, or other document as the case may be, and B, to any owner, holder, an unregistered right person who has lodged an objection or submission contemplated in section 7, subsection 2H, expropriated owner and expropriated holder at the address or fax number appointed by such person in terms of this act or in the absence thereof. 1, at an address supplied in respect of such person in terms of this act. 2, at the residential or postal address of such person if known to the expropriating authority, or if no address of such person is known or readily ascertainable by the expropriating authority, by publication in the manner contemplated in subsection 2A. So a notice as per subsection B3 is insufficient and any person whose interests are affected must be properly notified of the expropriation process. This cannot be left to the chance that they see a notice in a local publication, and more effort must be made to ensure that the person is notified appropriately. And the suggestion from the submission was the sheriff to be, and also maybe inclusion of email as a form of communication rather than the reliance in the place on only on post. Hand delivery and facts of communication is too old. Email must be included also. So we can add to all that by trying to put in the sheriff, hand delivered by the sheriff, and also the email, to add with the email, the amendment. Okay. The clause 25, subsection 2, a civil court may impose a fine up to the maximum prescribed amount in favor of the National Revenue Fund on a person referred to in subsection 1 upon application to the expropriating authority brought on notice to the affected person. So the concern is that the minister is authorized in section 26, subsection 1D to determine the final amount. This leaves too much discretion to the minister. There should instead be a framework or frame of reference for the determination of a suitable fine, or alternatively, the bill should specify an amount itself. The clause 26, subsection 1D. The concern is that the minister on this clause is given the power to determine maximum civil penalties when this could instead be determined within the bill itself. the consent for that. And clause 27, subsection 1, Roman figure 2, a regulation, it says a regulation or notice or an authorization document made or issued in terms of this act, B, may be amended or replaced without following a procedural requirement of this act if the correction does not change the rights and duties of any person materially. So I think the proposal, it will be a technical amendment to this clause. The use of word "and" means that both rights and duties must be affected to this provision to allow for changes to be made without following a procedural requirement. So the proposal, it will be that "and" be replaced with "or." Okay. And also the suggestion is that the interests be included so that the provision reads as rights, interests, or duties. And the proposed amendment is okay. So on the existing provision clause 1, the expropriation means the curtailment, like I initially talked to, of the rights of an owner in property for a public purpose or in the public interest by an expropriating authority or an organ of state upon request to an expropriating authority through compulsory acquisition of property as a form of direct expropriation or custodial taking or regulatory taking of property in the case of indirect expropriation. So existing provision is determination of compensation, which is the 12 subsection 3. It must be. So I read the existing provision clause and then the proposed amendment. Ne? Did I read the proposed amendment? So the existing provision, expropriation means the compulsory acquisition of property for a public purpose or in the public interest by an expropriating authority or an organ of state upon request to an expropriating authority, and expropriate has a corresponding meaning. So the proposed amendment of expropriation, it means that is the opposition, the one that I was reading is the proposal, the proposed amendment to that. So on the determination of compensation, clause 12, subsection 3, it may be just and equitable for nil compensation to be paid where land is expropriated in the public interest, having regarded to all relevant in circumstances included but not limited to, and it goes on until E, as you can see it on the bill. So the proposed amendment, it will be clause 12, subsection 3, it must go this way. It may be just and equitable for nil compensation to be paid where land is expropriated in the public interest, having regarded to all relevant circumstances. A, where an organ of state holds land that is not using for its core functions and is not reasonably likely to require the land for its future activities in that regard, and the organ of state acquired the land for no consideration. B, where previously expropriated property is expropriated for a new purpose from an organ of state or state department and compensation has already been paid. So that is the proposed amendment of the clause 12 of subsection 3. Okay. Where are we there? I think that will be from me all that we have. And members on the Western Cape government, if we can just go through quickly to look at the some of the issues that from Western Cape government that they raised. From the page 1, the clause 2 of 2B, is one of the issues on the bill was the issue of the working days, the calendar or working days. So the suggestion was where there is a calendar, it must be replaced with working days. And got that, ne? And then on the, do you have that, Kayla? There is a comment from the document from the Western Cape government. It's this one. You've got the hard copy? Okay, not yes. Okay, thank you. So on the first page, I think all we have one thing that yesterday was the clear picture of the public interest was the first one. That is the interpretation has to, I think that has to be, it should be clear what does it mean. And on the bill, they refer to calendar, and we want it to be replaced by working days. And then the proposed dates on where they talk on the period referred in clause 2, subsection 2B, or from the 20th December to 7 January, because of the holidays that are involved, it should be okay. Should be replaced by the period of as from the 5th of December to the 7th of January. Since there are holidays that are involved there, because if you say 15 already, the 16th is a holiday. December, the 26th, the 25th, the Boxing Day, the Christmas, and so and especially this year, we've got another holiday that is added to, like things might happen that way, that we've got another holiday that gets to be.
Okay, that will be on page 5. Page 5 for Kayla.
Oh, on that document she has here. Okay. And the other one was it suggested that any reference to departments in the bill should also include the relevant provincial department if appropriate in particular instance. Okay, do we agree to that? The legislature, so I have to ask, this comes from government, you have to, okay, you have to say yeah or yeah, it's not automatic. Yes. Thank you. I just want to make it clear that I mustn't read only when you are quiet. Okay, and on the next one of the definition of court, it is proposed that the draft definition for court is aligned fully with the definition for court in section 1 of PAJA. Members must include that in the negotiating mandate. Okay. The support was there yesterday. I noted some of the things that you were supporting yesterday. Definition of a date of expropriation.
Okay.
Thank you.
Maybe just on the point you made now about the definition for court. I'm not sure if that would be necessary to include it. Because you will appreciate that when we make laws, that legal instrument becomes part of the body of legal instrument. And unless there's a glaring or material contradiction or a specific use of a word, we don't need to define it again. It's been defined in other instruments already. So it would be superfluous, if not just unnecessary, to define it again. It's an uncontentious concept in this bill, unless the word court is used in a way or in a context that is contrary to our common understanding of the word, then we give it a definition. In the absence of that, the ordinary meaning ascribed to it should prevail. I'm suggesting.
To hear from the members in. Okay, so let me read quickly for you. Okay, so it says, no, it's better on the paper with my glasses. So it says it is clear that the dispute envisaged in clause 21, which really, I'm going to jump that one. So the definition for court in section 1 of PAJA provides that a court includes a magistrate's court, either generally or in respect of a specified class of administrative actions designated by minister by notice in the Gazette and presided over by a magistrate or an additional magistrate designated in terms of Section 9A of the Act. The definition in PAJA is broader than the draft definition for court in the bill. The draft definition read with clause 21 restricts the access a disputing party has to a court, in that the draft definition provides for a magistrate court within whose area of jurisdiction the property is situated. By way of example, a disputing party may therefore not approach a magistrate court other than the one where the property is situated, except in the case of intangible property provided for in paragraph C of the draft definition, and even in the case of paragraph C that is limited to the magistrate court within whose area of jurisdiction the owner is ordinarily resident. The draft definition is therefore not aligned with the PAJA. A deviation from PAJA is only permissible in terms of section 345 of that act in relation to fair process and reasons for decisions. It is submitted that the range of jurisdiction of magistrates' courts in relation to the administrative judges as provided for in PAJA must be incorporated in the draft definition for court in the bill. Furthermore, the draft definition assumes in relation to the magistrate court where the property is situated that both the presiding magistrate and the court have been duly trained and designated respectively in accordance with the section 9A of PAJA. Practically, this may not be a case, and then it not be clear to which court a dispute in terms of clause 21 may be referred. And paragraph C of the draft definition is confusing. Does intangible property include intellectual property and registered rights in the immovable property? So then in the case of the latter, those rights would fall under paragraph A or B of the definition. This confusion may lead to forum shopping. So, okay, let me ask Advocate Mastor, if I am in George, I've got the bad idea. If I'm in Cape Town, I've got a property that is get to be expropriated in Beaufort West. And then there's cost implication for me to travel to go for, let's say we end up in court and I have to go to Beaufort West to defend the amount of the compensation there. Doesn't this clause, the way it's structured to allow the issue to be lodged in Cape Town where I'm living rather than me going to Beaufort West? Thinking about the cost attached to that.
A person, they are defined municipal districts and magisterial districts, right? That's one. So there are quite a few magisterial districts in the province. And if a cause of action arose in a particular magisterial district, that's where it should be prosecuted or advanced. However, depending on the quantum that is underpinning the cause of action. So if I knock into your car in Kales River, we go to that local, etc. But if the damage exceeds the magisterial jurisdiction's prescribed competence, it goes to the High Court, right? 1. 2, the High Court, however, regardless of where an event may have taken place, has jurisdiction throughout the province. Right. 3, this bill, as is the case with any law, is basically a policy document, and it provides for how things should happen. The drafters intend that a matter regarding expropriation should be at the level of the High Court. That's the proposal in this policy document. The public, lawmakers, may propose a different jurisdiction for purposes of cost implications, etc. So, in as much as the bill proposes that the High Court should have jurisdiction, because of the issue of expropriation and its potential impact on ordinary people, it may be prudent, if not progressive in terms of access to justice, to recommend that the definition in respect of court should not just be limited to the High Court division, but should in fact include any magisterial district to make it progressive and accessible. Cost is not relevant, but accessibility should be the primary consideration. I say cost not relevant, I should say cost is less relevant. Accessibility should be maybe primary. So under the definitions, this bill proposes that court should be the division of the High Court. My understanding from the submission is that it should be court as envisaged in PAJA, which says any lower division. Yeah.
I agree with the proposal. I think it is progressive to consider the role of the magistrates of courts as well. So I'm comfortable. Thank you, Chair.
So we must leave court and not ask for the definition of court as section 1 of PAJA. Okay, Member Sleko?
I'm fine, Chair.
With
the proposal.
there are 2 proposals. Which one?
The one that we can leave it as it is, Chair.
Okay, thank you. Member Isaac and Member Class. Which one?
Otherwise, it said leave as it is.
Okay, thank you very much. Honorable members are progressive. Okay, so we are at the definition of date of expropriation. And I think I talked to that already.
Property.
The definition of property, that's a huge one. So the draft definition simply means, and the proposal is that the draft definition of property is reconsidered to provide clearly and ambiguously what property will fall within the ambit of the bill. So that is one thing that we also have to get the clarity that it should be the defined We don't have a suggestion about that. Do we? Members? Any suggestion of what, when they say property, they should say what? Member Maren?
Jay, sorry, I'm just taking a minute to reread this. I note that they say section 25(4)(b) of the Constitution merely provides that property is not limited to land. I do agree that the draft definition is unhelpful, but I think in remarking on property, we need to remark in terms of the definition relating to the intended purposes of the bill to effect meaningful land reform, because as it stands, this definition of property doesn't, to my mind, show that it intends to create meaningful land reform. So if they are to insert a definition of property, I would say that that property needs to align with the purpose or the ambit of the bill itself.
The challenge to it. So it has to be aligned to the purpose, and who determines the purpose. And that's the way it is, like the purpose, who determines the purpose if I'm going to expropriate? And what property, what is it that I'm going to expropriate? That's where it comes in to say that when you say property, what do you mean? Are you going to find that I've got a shop there and then you are going to expropriate, and then why are you going to expropriate? So it will be, the purpose is that because for special planning, there is a road that I have to build there. So I'm going to shift. So there's a cost attached to that in expropriation and blah, blah, and all that. But does the town where the shop is, do they have another shop somewhere? If you are going to remove that, you are going to expropriate it. That means the shop is going to be closed. So that's why I'm saying the purpose have to say, what you are saying makes sense, but now who determines the purpose? Because the town, let's say the village will say, we've got only one town. This is you cannot expropriate because where are we going to buy bread and milk and all that? So who determines the purpose? And like you are saying that it's important that the property, the definition of property, and we are going to follow up with the public interest and the public purpose interpretation to say that definition, what does it mean? I put a bigger that as we go to the public purpose, public interest to say, so that we can also somehow think about it, that how do we go about? So the scenario is that the minister, Masdot, is expropriating this shop because for special planning, to correct the special planning, the road has to come here for transport, for accessibility of people to be easy for them to go to work because the bus service is coming here. But in this town, this shop that you're expropriating that is on the way is the only shop that the community depends on for their supplies that they need on a daily basis. And how do you interpret to get the property, to get the public, and then the public purpose and the interest?
Chair, if I may, I don't think that at this point, given the nature of the bill and the extensive need for redrafting, that we are in place to define property. But I think it's important for us to note the questions that are unanswered in our negotiating mandate. So, for example, what do you mean by property? Who is that property intended for? Who does that property belong to? What sort of property? Who determines which property is used? I think we use it as an opportunity to really ask and find out, what do they mean by property? Because I don't think that we can define that. Yeah.
No, Chair, because I'm just reading what they are saying in terms of the definition of property. And they are not being specific per se, say how it should be defined. And this it will be I think we should just let it go to the NCOP as it is, that they should look at it, because I think this is not the only, because from your own input, Chair, as well, I think the issue of property has been put there, that because there's a different interpretation when it comes to expropriation in terms of what they define as property. And I've also asked the same question to the department, that do they think that how property is put in the constitution, is it good enough? Is it clear enough? And I think that is something that, the drafters of the bill must be able to say, in terms of how they would define property, because property to me means something else. Property to Kayla means something, because her hair, she can define it as her property. But when it comes to expropriation, how do we define property? I think that's where the vagueness in terms of property comes in, Chair.
It's one thing that was raised for the issue of the response from Mr. Ndu he said in the response that it's as defined in the Constitution. But now it raised the thing that you mentioned, that there are some communities that their property, like a church, is owned by God. So how are you going to expropriate? They will say it's owned by God. How are you going to expropriate from God a church? And is it, when you expropriate it, public interest, public purpose? And so I think that is one thing that we have to get the clarity. It should be clear and concise, the meaning of the property. What do they mean by property? And also it will fall to who determines the public purpose and the public interest. Because it's going to take it's going to take us, and then we will hear from them. So Maraf, that Advocate Mazda, that's where you come in.
Chairperson, it is true that property is not sufficiently defined or circumscribed in the Constitution. That's fine, because the Constitution really is a framework document. But in proposed legislation of this nature, I think it's a glaring omission to not define the notion property. In fact, in this very bill, property and land are used interchangeably, and that doesn't help. One of the submissions from a member of the public shared that the moment we hear of expropriation, we become anxious. Like I said, it's a glaring omission that it is not defined, and a recommendation can be that it should be defined. I know that property can, and in fact does, involve all manner of things. In fact, property can even include something which doesn't exist. Because if you grow crop, I can agree with you now that the crop you will produce in 3 years, I want to buy it from you. I've got a right ensuing from that agreement. Even things I cannot touch can be property. So I'm repeating that it's a glaring, if not an embarrassing omission to not define the concept property, especially in a bill that is as impactful and anxiety laden as this one is. So what would have helped is if property was defined along the line, for purposes of expropriation, property is defined as immovable property or land. That would have been a prudent and an informed suggestion. But just to invoke Section 25 of the Constitution, whereas that section does in and of itself not even define property, is a cop-out and is poor drafting. So I wouldn't support this definition because it doesn't help to read the bill, and it doesn't also help people who will be impacted to understand whether they are vulnerable to the impact of this bill.
Sorry, just my question on that. Are there any, and this is perhaps for Advocate Marstal, are there any legal instruments that we can rely on that define such property? Yeah. Are there any legal instruments that define immovable property or land that we could draw on for the definition?
Well, there's you say legal instrument. I would suggest maybe a legal source. There's textbooks on the law of property where property is defined. Anything that you see, it's law corporeal stuff, tangible stuff, and incorporeal stuff, intangibles, and spares, a hope, whereby future crops also property. So I'm saying that's why I said if we want to make a useful contribution as far as property is defined in this bill, one can say, for in as much as property is defined somewhere else, for purposes of giving effect to to this bill, we define property as land and immovable property. I'm saying so you work from the general to specific. You craft the concept to give effect to this bill. We're not purporting to redefine property, but to give effect to the purpose of this bill. Property will be land or fixed immovables on top of that land, just to give effect to this, and not trying to reinvent. So in as much as there's plenty texts to define property, and one can even just do an ordinary search, it will take you to Timbuktu on what property is, and it won't help to give effect to the purport of this bill. That's why I'm saying this bill should, in fact, from the body of what property could be, it should constrict it to give effect to the purpose of the bill. I would circumscribe property as, for purposes of giving effect to the intended purpose of this bill, property is defined as land or immovable property. Then you don't worry about my car and my etc. Or IP, etc. In any case, the bill doesn't help itself by interchanging their concepts with land and property.
The reason why maybe I suggest that way, there is property or land. We replace with immovable property or land. Just to put that in everywhere where is that. Okay. And the clause 2, okay, clause 2 point, where were we? Okay. Clause 2, subsection 1 of 2.
Public interest.
Is it so the public interest summary we dealt Didn't I do, I think when I did the submission, my submissions, I talked to the public interests and the public purpose.
Yeah.
We talked to that, no?
Yes.
Okay, so we are on the clause 2, subsection 1 and 2. The proposal is that consideration be given to expand the provision to provide for instances where state-owned entity has a direct interest in the land. For example, land forming part of the country's conservation. But that, I don't know, this is, it's a specific, I don't know how to. Is on 5 of the clause 2, subsection 1 and 2 provides that despite the provision of any law to the contract, an expropriating authority may not expropriate the property of a state-owned corporation or a state-owned entity without the concurrence of the executive authority responsible for that corporation or entity. What do you say about that, members? There it is. It's page 5. It says, okay, although the state does not necessarily own the property that forms part of the country's conservation estate, it does, however, have an interest in the land in terms of meeting its international conservation targets. Concurrence from, or at least notification of and possible engagement with the relevant executive authority should be required for the proposed expropriation of a property forming part of the country's conservation estate. Although clause 5, subsection 1b alludes to an acknowledgement of rights, it does not necessitate concurrence from the executive, which would be important in these circumstances. It is suggested that consideration be given to expand the provision to provide for instances where a state-owned entity has a direct interest in land, for example, land forming part of the country's conservation estate. But now, I don't know, because the expropriation, is it expropriation from private or it's expropriation to where it has to serve the public interest and the public purpose? Remember, Mari?
Chair, my reading on the comment from the department is that they are saying that we need to focus on instances where the land is publicly owned. So I think that is important to focus on. And the clause as it is seems to sort of deviate, to put it like that, from the possibility of expropriating state-owned land by talking about the land that may not necessarily be owned by that department. But then also it speaks to the country's conservation estate. I'm not 100% clear on what that means, but I suppose it relates to land that we want to protect the fauna and flora of. So I'm just thinking on how to take it forward for clauses 2 and 1. I do think they need to be more clear on what sort of land can be expropriated belonging to the state that is public owned. So what, for example, do you do in the event that that land is earmarked as a conservation area? Or what do you do in the event that that land is occupied by the state but not necessarily state owned? Or what do you do in the event that the land is owned by the state and can be expropriated? But I think it raises a broader question of, can we expropriate? Can we use this bill to expropriate from government itself rather than from public persons? And I'm not clear, actually.
Okay, so here it says that the country has got the responsibility in the country's conservation estate that they have to reach a certain targets, the international conservation target. Okay, that is taken. But now, when they say that when coming to the expropriation, there need to be sort of consultation with the executive authority if they are going to expropriate maybe on the nature reserve or that. The question is that, again, it will be that why would the government expropriate the land from itself without talking to itself? Get what I mean? Advocate Masdar, are we missing something from this comment? Is it the clause 2, 1, and 2? Let's talk about the notification and possible engagement for the proposal of when expropriation maybe is going to happen where there is a nature reserve. Something like that, that provision has to be made in the bill itself where a state-owned entity has a direct interest in the land, for example, land forming part of the country's conservation estate. So my question is now, why would a state expropriate something that it got interest in from itself without talking to itself?
It can't expropriate from itself.
Exactly.
Yeah, and expropriating authority is defined here, and only that entity can be the minister. May, in terms of this act, this bill, may expropriate, but you can't expropriate because expropriation presupposes non-ownership, non-control over the right to that property, land. And in order to obtain control/rights to that property, you expropriate it for public purpose or whatever reason. So you can't expropriate from it. You can maybe, there's some other governmental instruments to be used.
Because much as it can be a nature conversation as an entity, Cape Nature, but your assets internationally, when you say how much conversation do I have my target, you count that. So automatically that means you are owner to that and you cannot expropriate from yourself, like Advocate Masdorp said. So that proposal, it's not needed because it cannot happen in that form. Does it make sense? Okay. So the clause 2, subsection 1, oh, Jesus Christ, I'm hungry. And 2. Okay, oh, there is the notes that come from government. Okay, the new clause 2, subclause 1 now includes exercise of the old subclause 2 has been deleted. This addresses the Western Cape comment regarding, okay. They say that is on the new document that they did. They say they deleted that in my land has been deleted. Okay, sorry. I've got a lot of papers around me. And then 3.3 on the clear what is meant in terms of minister's mandate. It is intended to mean that the power in clause 3 may only be exercised on behalf of organs of state with functions that fall within the scope of public works and infrastructure portfolio. Clarity is required. I don't have the bill here. What does it? Okay, it says it has been redrafted to require the relevant MEC of the organ of state requesting the minister to expropriate property on his behalf to make the request in writing. The words in terms of the minister's mandate were removed. Okay, so we don't have to talk to that one. It's been removed. And for 4 words conferred or imposed on him or her in terms of have been replaced with under there, as replaced with under. And then the issue of the municipalities also is still there, it still has to continue. So it is proposed that clause 4 must be reconsidered to expressly provide that the powers of the minister in clause 3221 and 231 subsection 1 must be capable of delegation and assignment to municipality. So the clause 322, section 22, subsection 1 is being dealt with. It's only the 23 subsection 1 that is not being addressed, that it stays. Okay, I'm going to, can we leave that one? Okay, thanks. And the clause 5, some grammatical changes have been made to improve this clause. For clause 5, subsection 1b, the words and the impact of such rights on the intended use of the property were deleted. A new clause 5, subsection 1c was added requiring the ascertaining of facts regarding the calculation of compensation and the duty to formulate a compensation offer. The reference to inside in clause 5, subsection 4d, Roman figure 1, has been substituted with references to access. So inside has been replaced with access to building plans. Clause 5, subsection 5a now applies to mortgages. Clause 5, subsection 7 now only requires an expropriating authority, being EA, to make the contemplated repairs if given notice by the owner. New subclauses 9 and 10 have been added. The first regarding protection of personal and private information. The second about authorizing a valuer to consider property other than land. The Western Cape government's comments were not addressed. Okay. This clause has not changed in substance, and so the Western comments were not addressed. It's the clause 6. So the clause 6, subsection 1, it talks about the, in terms of liaising with the municipality, in terms of the effect that the expropriation might have on municipal planning. The same principle holds true for provincial planning. It is therefore suggested that this provision is extended to include the responsible provincial department as well. So it is proposed that clause 6.1 is amended to include provincial planning and the provincial department responsible for provincial planning. Members, in agreement? Okay, yeah, in agreement. And the 7.2, the word physical be inserted between the words there and physical address. That is in agreement. They change. And clause 7.2, it's an agreement. The 7.2H is in agreement, and the clause 7.7A okay. We are on the clause 8. Okay, the clause 8 now includes mortgages and requires the notice to be served in the recipient's chosen preferred language. Now, that is the one thing that I don't understand. So the clause 8 is subclause 1 now includes mortgages and requires the notice to be served in the recipient's chosen preferred language. I mean, you are going to give the notice, you haven't met this person. How are you going to know the preferred language? Still going to find this person. Does it make sense? Yeah, I mean, there it has to be in the, you have to be in the, yeah. Use the 3 official languages of the province, or we have to put the, how do we put it, Advocate Master? You got me what I mean. That the notices have to be in the official languages of the said province. So that's what we install there. Not how do you haven't even met the person really? Okay, and then that is the 8, and then except in paragraph, the notice is published in terms of clause. The notices, even published, it has to be in the official languages of every, if published in the newspaper, it has to be in the official languages of the provinces, of the said provinces, where whatever expropriation is happening. And the subclauses of FG, which is, okay. We are done with that. The days, I think I talked to that on the other, on the days, yeah. And the clause 12, I think I'm not going to go to 12. 12 already, we talked to it. I submitted to you. You'll have to look at that already. We talk about one and the same thing as per the on the government. Now the clause 13. Okay, that's where Advocate Milestone. Can you talk to us about the clause 13 from the government? They talk about it, propose that clause 13 provides that interest on compensation payable for expropriation is kept by the in Duplam rule.
My understanding, Chair, is that the interest should or could only be calculated or compounded to the extent of the value of the property. So it can't be in excess of that. Interest compounds. What this means is that it should be kept to the point of the value of the capital property, capital asset, and not go beyond that. So the interest can't be worth more than the property itself. There you are.
Okay. The next thing you'll be saying, yeah, Dr. Wanzo. Too soon. Okay, so clause 15. Okay, do we agree on that one, hey? The clause 13, yeah, we agree on that. 15.3. It's assumed that the child licensing clause will start running with particulars are requested in terms of clause 16, subsection 1. If the assumption is correct, then it's submitted that clause 15, subsection 3 must make this explicit. It's proposed that clause 15, subsection 3 is redrafted by inserting the following words to the introductory sentence. subject to section 16, subsection 1. Members, you've got your bill name. (16.1). Okay, so they say that it's proposed that it's redacted by inserting the following words to the introductory sentence. If property, so where do we put in that? Subject to section 16.1, where must we in 15.3? Section 15.3, any delay in payment of compensation to the expropriated owner or expropriated holder by virtue of subsection 2 or any other dispute arising will not prevent the passing of the right to possession to the expropriating authority in terms of section 9, subsection 2 or 4, unless a court orders otherwise. But now if they say 15.3, the clause 15 subsection 3 has to start with subject to 16. So it will be subject to section 16, subsection 1, any delay in payment. Okay. Members?
No, Chair,
Yeah.
in terms of section 16.1, I think it's unclear whether if you've got an outstanding debt in terms of your mortgage, let's say it's 1K, it's 1M, and then the state says in terms of the value we want to give you, it's 200,000 less. What do we do? You know, so who's gonna carry the difference that you owe the bank? I think that's where the clarity sticks. Is it going to be, are we going to be level, you know, in terms of the debt? Because I think one of the comments from Member de Villiers was that most of the people that have acquired property has went to the bank to take out mortgage bonds. So one would not want to be compensated less than what you owe the bank. I think that's where we say, you know, we need to clarity in terms of that. How is it going to be implemented, you know, should one go to that extent?
Yeah, I already submitted that one when I was doing the submission to say, and in fact, it went. Okay, so I'm talking to the section 15.3 because that one I even went further and said that. So if you bought a bond you took a bond of 1.5 and then expropriation equals to the settlement amount of bond, you need also, there is an investment also to say that what extra amount that's going to come to you for that investment, because that was your investment. You cannot settle, let's say you took a 2 million bond and then you go to the bank and the bank said the settlement amount is 2.2 and expropriation authority says they're going to settle that bond. That is unfair to you because that is an investment and in one way or another it has accrued the interest for you to can have something extra. So it has to be clear also of, it have to be consistent cognizance of that issue that the property is an investment to that. But anyway, we are not there. We are in 15 subsection 3 where we are going to insert 16.1 subject to section 16 subsection 1, any delay in payment. No? Okay, we are in agreement with that. All right, thank you. And we are in 17.3. It is proposed that clause 17.3 is reconsidered and redacted. I hate it when I hear that one. Okay. The provision of this law may lead to a situation when owner or holder is without their proper compensation. Already addressed this one from my submission. And when the claimant complainant in this clause is not tax compliant or is not able to produce the tax, invoice, does it mean, okay, this will take as it is. I don't know how are we going to, any suggestion for this? We'll take it raw as it is. Of the text non-compliant. Advocate Masdop, do you raw as it is? Okay, we'll take it raw as it is on the comments or on the questions to attach to that. 18. It is not clear. Okay, we just talked about that. And 19. Clarity is required on what the reimbursement payment arrangements will be in respect of any overpayment of pro rata rates by the expropriating authority to the expropriated owner or holder. I don't understand that. Anyone who has a clue of that one? It is 19, subsection 3.
What does that now say?
Okay, you gave me a page, where's the page? 19. 19 is payment of municipal property rates, taxes, and other charges out of the compensation. It doesn't talk to it the
Relating to municipal rates.
Hmm?
Municipal rates.
Yeah, I think it talks to the municipal rates of the, so, okay.
Chair, I think the question is, if municipal rates were overpaid, then how do you compensate the owner?
Yeah, so if I take that, I've got my rates, I pay per year. You expropriate February and I pay January for my rates. So how, it doesn't talk to say, how are you going to reimburse me for my rates that are already paid for the year? Am I right to think that way? That's the case.
I also think it's like, at what point of the expropriation process are you cut, or do you stop paying your rates? Because it's quite a lengthy process of going through that tribunal, getting the notice, that notice being reviewed. So within that entire process of an expropriation, when do you say, okay, now I don't need to pay the rates anymore? Is it the point where you have officially unoccupied the premises and handed it over? Is it when you receive a notice to say the expropriation has taken place? What is that defining point?
Advocate Mazab, help us.
Again, this bill becomes just one of a myriad of other laws which already exist. And in that scenario, an owner is responsible for his or her obligations as owner in relation to the payment of rates and associated taxes until such time that the property is registered in another entity's name. So you have an obligation until the expropriating authority has registered it. The day of receiving notice is just the initiation of a process. That process may even run for years because there may be dispute upon dispute, and a court may be introduced to settle a dispute, etc. In the meantime, your obligations vest as title holder. So your question, at what point does one stop? As soon as the property is registered in another entity's name. It can't be any other way, because then this law would completely contradict existing practice and law, that registration entitles ownership and the ensuing responsibilities, you know.
On registration or re-registration
Yeah.
of the ownership. So once that ownership is moved. But I'm not clear exactly on the wording of 19.3b. Does it say upon registration?
What reimbursement payment arrangement will be in respect of any overpayment of pro rata rates by expropriating authority to the expropriated owner or holder? Anyway. Okay, so is there, we are talking about 19 subsection 3B. The clarity in 19.3b, it says the disputing party may, instead of instituting such proceedings himself or herself within 90 days of date of the notice of expropriation, request expropriating authority in writing to institute such proceedings, and expropriating authority must institute. It doesn't even, no, they got it wrong. Okay. What is here and what I say here is not the parallel things. Okay. So we are on clause 19.4a.
But actually, they removed it out of
They removed that. Okay, they removed that one out. Okay. So the 19.4a, it moved, ne?
Yeah, it's
Also removed. Clause 21, it is proposed that mediation is used for all expropriation related disputes.
Yeah.
That is, we agree to that.
Yes.
And the clause 21, 6, 7, and 8, a challenge in terms of process of compliance with the act should suspend the expropriation pending the cause determination in this regard. The clause 21, subsection 6.
Now they've taken it out.
Now they've taken it out on the.
I only got 21 subsection 3.
This is the old document, so let me check the new. Give me the new one.
The new one.
Okay, the 21 3B is a reference to the register of deeds and to title deed in the provision. The 3-month withdrawal noted. We are going to leave that one, is clear. And the 25 subsection 2. It empowers, clause 2 empowers a civil court to impose a civil penalty on a property owner who fails to respond to notices issued by an expropriating authority. It is submitted that the provision must distinguish between cases in which a property owner requires assistance to respond to the notices from the expropriating authority, as opposed to cases where the failure to respond is deliberate. Okay.
Chair, just on 22. Just an observation, really. It's nothing legal, but, you know, National Parliament, and in particular my colleagues there, have this this mission to use plain language. It's progressive because you want people to know what will impact their rights and their lives. And yet, in 2023, we make references to fideicomissum and fideikommissaries, etc. I would certainly recommend that the Latin phrases be removed and that equivalent English phrases be inserted. And if they can't find that, then they can certainly consult WCPP legal advisor for that. But to remove the Latin references there, Chairperson.
Chair lady, can I ask please something? It might be just a miracle that they finish quicker. Can they call us when they're done, not later than 4?
I suspect they will do that if they are done, but also just to cut the time, it will be when they're done, the first person to check it out, it will be Advocate Masdorf to check that if we identify things that we are done, we said and they're outside the legal then he will quickly look at that. And then when he comes back, then he identifies that. And then we talk to that. We look at everything that we identified, if it's in there. And then we adopt that. Then we know it's ready to be sent tomorrow. Will that work with all of us? Thank you very much. And let's adjourn now. And because I have to talk about time, when are we coming back? I'm going to say 4, but it might be before 4. Thank you very much. The lunch is ready. I love hardworking members, is the members of the Standing Committee of Infrastructure that work hard I can put it on record in the chambers that the members of the Standing Committee in Infrastructure, including Advocate Masdorp and Procedural Officer Shumis Jones, Senior Procedural Officer Lizette Klute, and Assistant Committee Mrs. Masintle. And their surname is very difficult, and then Makoti. So it's very, those are the most hardworking people in this legislature. So that is on record. Members, we are at the time of, if you can share on the screen, this is the negotiating draft committee report, negotiating mandate that we have to adopt. And it reads as this: report of the Standing Committee on Infrastructure on the Expropriation Bill B23B 2020, COP dated 14 November 2023 is as follows. The Standing Committee on Infrastructure, having considered the subject of Expropriation Bill B23B 2020, and COP referred to the committee in accordance with the Standing Rule 217, confers on the Western Cape's delegation in the NCOP the authority to support, not support the bill with the following recommendations. It's not support the bill. Yeah, I'm going to ask the members. Okay, can we go block to block? Not support or support the bill? Okay.
Not
Can you put it on record by them?
Not support, Chair.
Mbulela Isaac Saleko, not support.
fully 100% with their decision. Thank you.
Yeah, I'm going with the meerderheid.
Thank you very much. It's unanimously agreed to not support. And the clause
Recommendation.
and then the following is not support, the authority to not support the bill with the following recommendations. Clause, the definition of court. The definition of court makes mention in subclause C2 intangible property. There are a number of considerations around intangible property that will require its own specific guidelines for expropriation. Therefore, we propose that either additional guidelines are brought into the bill to deal with this, or that the definition of property be amended to exclude intangible property. The second one is the definition of disputing party. The definition of disputing party includes an owner, mortgage holder of a right contemplated in Clause 20, expropriated owner or expropriated holder who rejects the expropriating authority's offer of compensation. The committee disagrees with the removal of counter offer in final version of the bill. And for holder of a right means the holder of an unregistered right in property, but excludes an unregistered owner. The committee proposes that this definition should also include a registered right. Compulsory acquisition of property. Expropriation is defined as the compulsory acquisition of property for a public purpose or in the public interest by an expropriating authority or an organ of state upon request to an expropriating authority. An expropriate has a corresponding meaning. The committee proposes that the definition should include the curtailment of rights, such as an inability to use a property for business purposes. Further, it remains unclear if this definition includes temporary expropriation. The public purpose is defined as any purpose connected to the administration of any law by any organ of state, in terms of which the property concerned will be used for the benefit of the public. The committee proposes that this definition be amended to provide more clarity. Valuer, the valuer means a person who is suitably qualified to value particular property and includes a person registered as a professional value or professional associated value in terms of Section 19 of the Property Valuers Profession Act 2000. It's the Act 47 of 2000. The committee proposes that this definition be amended to circumscribe suitably qualified. Question, clause 3, subsection 3 is redundant as it will be covered by clause 3, subsection 2. Furthermore, it is contrary to the purpose of the bill as it does not directly relate to a public purpose or public interest. If such expropriation examples were to meet to the requirement of public purpose or public interest, this subsection would be redundant. Clause 3, subsection 5A says when the minister expropriates property in terms of subsection 2, the ownership of the property vests in the relevant organ of state on the date of expropriation. The committee proposes that this provision be amended to make provision for payment of compensation as a prerequisite for vesting. Clause 5, subsection 1. Clause 3, subsection 5A should be amended. Land is an emotive issue and subjective factors can come into play when determining its value, particularly when an owner is being forced to give up their land under an expropriation situation. Consideration to be paid to subjective elements, including financial and sentimental value, rather than a purely objective assessment. Other considerations, including the cost of relocating and other costs associated with leaving the property, it is suggested a clause similar to what existed within the Proceedings Expropriation Act, figure 2, an amount to make good any actual financial loss by the expropriation should be included. This consideration can either be included in this clause or alternatively in clause 12. Clause 5, subsection 5, it is recommended that longer timeframes be included throughout the bill that are more realistic than the commonly referenced 20-day period. For a matter as important as expropriation of property, significant time should be given to all parties to ensure compliance with detailed requirements. Clause 5, subsection 7, if the property in question is damaged through an act contemplated in subsection 2, an affected person may deliver written demand to the expropriating authority, and the expropriating authority must repair the damage to a reasonable standard or compensate for the damage without undue delay. And in amending, greater specificity is required in respect of who determines the extent of damage and the quantum of damages. It is suggested that a baseline assessment of the property be conducted prior to any work performed so that an objective assessment of the extent of the damage can be conducted. This will protect both the state and the owner.
The committee proposes.
Yeah, the committee proposes.
Yes, good.
Amendment. Yeah.
Amendment include greater specificity in the meaning.
Advocate Master, check there, this great. The committee proposes that an amendment to include greater specificity is required. Must we do
an amendment? Should we say that greater?
Go up a little bit so that he can see.
Include that greater.
Yes, yes, Chairperson, I read that earlier and didn't pay much heed to it for the following reason. An affected person may certainly make representations to a minister or an expropriating authority. But in terms of going onto site, looking what the damage is, the extent of it, how long it will be take to repair, etc., that sort of minutiae that for me belongs in the realm of operations. So it could very well be that the expropriating authority or the minister may make regulations that will say, in an instance where notice of damage or etc. has been received from an affected party, the HOD or a delegate in his or her stead may attend and. So it is somewhat operational. However, that being said, if the committee has a concern that the actual entity or the actual official or representative on behalf of a minister must be identified in the form of her or his office to make an assessment as to damage, the extent or the quantification thereof, then one can certainly include that. I just didn't pay heed to it because that is certainly an operational thing which will be ondervang, which will be provided for in the regulations, or which can be provided for in the regulations. I would have no qualms if it's just like that.
We wanted to the proposal of the committee is the amendment. It's what we want to put in, that there is a greater specificity.
Yeah. So one could, for example, say the committee proposes that greater specificity be provided in respect of determining the extent or quantum of damages. And then full stop, and then second, this may be done via regulations. There you are. Well, this may be provided for in ensuing regulations or subsequent regulations.
Sorry. Okay. A reasonable standard is also not sufficient. Any damage should be repaired as close to the original state as possible, or sufficient compensation be provided to restore all damage. Furthermore, damage should not be limited to just tangible property. The damage should refer to damage incurred by the owner, which could include negative impacts on livestock or ability to farm as examples. Okay. Clause 6, subsection 3 says the municipal manager must deliver a written response to the request contemplated in subsection 1 within 20 days of receipt or within a reasonable time to be agreed between the expropriating authority and municipal manager. The committee proposes an amendment as there are no clear consequences outlined should a municipal manager fail to adhere to this time frame. Given that non-compliance may result in a material delay in the expropriation process, clear consequences and remedies should be outlined. Clause 7, subsection 2H. Roman figure HI plus Roman figure 2, clause 7, subsection 2, Roman figure HI, which is 1 and 2. A notice of intention to expropriate must include an invitation to any person who may be affected by intended expropriation to lodge with the expropriating authority at a given address within 30 days after the publication of the said notice, subject to section 25. Any objections to the intended expropriation and any submissions relating to the intended expropriation. The committee proposes an amendment as it is unclear that these objections are given any weighting or if they must merely be considered. There is a need for the objections and submissions made in clause 7 subsection 2 Roman figure H and 2 to be considered and for them to potentially have a material impact upon the final decision to expropriate. This is currently not provided for. It is proposed that this provision instead form part of the investigation phase, as this will have more impact and weight in this phase of the process. Clause 7 subsection 3. If the property contemplated in subsection 1 is land, the expropriating authority must also deliver a copy of the notice referred to in subsection 1, 2, and that continues. There are specific requirements for expropriations involving land, including to send a copy of the notice of intention to expropriate to additional government departments. However, for other types of property, no such additional requirements are present. The committee proposed that these provisions be considered. Clause 9. Date of vesting of property should be upon registration and not just the date of expropriation. Sorry, just go back after 9. I just want to. So clause 7, subsection 3. If the property contemplated in subsection 1 is land, the expropriating authority must also deliver a copy of the notice referred to in subsection 1. And then we're saying there are specific requirements for expropriations involving land, including to send a copy of the notice of intention to expropriate to additional government departments. Okay, no, I hear it. Okay, so we can continue. Clause 12 of the bill deals with the determination of compensation. Subsection 1 provides the relevant circumstances to take into account when making the determination. This section does not address encumbrances on making the determination. This section does not address encumbrances on the property, particularly with respect to mortgages. Section 18 addresses how the expropriating authority should make payment to the holder of a mortgage, but it is committee's contention that a mortgage should form part of the initial assessment of the amount of compensation under section 12, as it plays a significant role in determining the value of the property. Once again, the assessment should be done by a suitably qualified and registered professional. The bill also does not provide for any engagement with a bank or holder of a mortgage, despite the significant interest in the property concerned. It should be noted that nil compensation is unconstitutional within the Section 25 framework. Given that the 25th Amendment Bill did not pass, the expropriation bill needs to be redrafted to be consistent with the Constitution. Instances to retain the current wording will render the bill unconstitutional, not only because of the aforesaid inconsistency, but also because it will be an attempt to amend the Constitution through ordinary legislation, rather than through a process that complies with the requirements set out in the Constitution for a constitutional amendment. It cannot be argued that the bill in its current form does not seek to amend the substance of the constitutional provisions contained in Section 25. If it was previously agreed and accepted that a constitutional amendment would be necessary to enable nil compensation, expropriation without compensation, then it cannot be enacted through the back door by this bill, given that the constitutional amendment did not pass. In light of the fact that public participation on the expropriation bill was conducted on the current version of the bill as inextricably linked to the now defunct 25th constitutional amendment bill, it will in all probability be necessary to subject this clause to fresh public participation, given that the constitutional amendment did not pass. South Africans must be consulted again on the way forward in light of the changed circumstances. Section 25, subsection 2B states that the amount of compensation, the time and manner of payment thereof must have been approved by a court. This section eliminates this consensus and usurps the authority of the judiciary as it predetermines the amount of compensation to be nil in these defined circumstances. Clause 12, subsection 3A. Okay. This amounts to interference by the state in private property rights. The state should be in a position to decide whether or not an individual has a right to hold property for any of the reasons cited. This would have a direct effect on property speculation, which is no different to speculation on the stock market and not in conflict with any law. Clause 12, subsection 3C, this cannot be sufficient cause as the failure to exercise control may not be the fault of the owner. Clause 12, subsection 3C, this cannot be sufficient cause as the failure to exercise control may not be the fault of the owner. Clause 12, subsection D, there is a concern that this clause could result in perpetual expropriation, where the beneficiary of expropriation or land reform could subsequently have their land taken for no compensation. Clause 12, subsection 3E, this is not sufficient cause to warrant the expropriation without compensation. Risks or hazards can be rectified without having to resort to expropriation. This creates a new criteria for expropriation to eliminate or rectify risk or hazard. Clause 14, subsection 1, the owner, mortgage, and holder of the right may request the expropriating authority in writing to provide reasonable particulars about the offer of compensation or the counter offer as applicable and particulars so requested must be finished within 20 days of such request. 2, if the expropriating authority fails to provide the requested particulars, the person making such a request in terms of Section 1 may on notice apply to court for an order directing the expropriating authority to comply with subsection 1, and the court may make such an order. 3, an offer of just and equitable compensation and a counter offer remains in force until A, revised by expropriating authority, B, the amount of compensation has been agreed upon, or C, the compensation has been decided or approved by court. The committee disagrees with the removal of the counter offer references, and the committee believes that greater support should be provided to the claimant in making such requests. At present, a court order is required by the claimant to force the expropriating authority to comply. This is costly for an individual, and other more affordable mechanisms to enforce compliance should be available. Clause 15, subsection 3, any delay in payment of compensation to the expropriated owner or expropriated holder by virtue of subsection 2 or any other dispute arising will not prevent the passing of the right to possession to the expropriating authority in terms of section 9, subsection 2 or 4, unless a court orders otherwise. The committee opposes clause 15, subsection 3, as it is very problematic. The expropriating authority could delay the process, which may unfairly prejudice the owner with position passing without consensus on compensation. This clause is therefore heavily weighted in favor of the state. Clause 16, subsection 1, if the property in terms of this act was immediately prior to the date of expropriation encumbered by a registered mortgage or subject to a deed of sale, the expropriating authority may not pay or out any portion of the compensation money except to such person and on such terms as may have been agreed upon between the expropriated owner or expropriated holder and the mortgagee or buyer consent, as the case may be, after the claimant has notified the expropriating authority of the agreement. There is no guarantee that the mortgage will be settled, and a scenario could exist where the compensation paid is sufficient to extinguish the debt of the insufficient. Okay, say that again. Yeah. Okay, there is no guarantee that the mortgage will be settled, and a scenario could exist where the compensation paid is insufficient to extinguish the debt of the mortgage, which leaves no compensation for the owner of the property. Banks also wield more financial power than owners, and as such could ensure they secure their portion before the balance is allocated to the owners. This could see owners left with nothing while the banks have had their debts settled. Clause 17 4C, despite provisions of any other law, the expropriated owner remains liable to the municipality for rates and other charges levied on the property until the right to possession vests in the expropriating authority in terms of the section 8 subsection 3F or section 9 subsection 4. The committee opposes this clause. If the date of possession is later than the expropriation date, the municipality may hold the former owner responsible for municipal costs. This clause is patently unfair to the former owner and must be amended. The committee proposes that it could be amended to read, or the ownership passes to the expropriation authority, whichever occurs first. Clause 19, subsection 8. Any appeal against the decision of a court on the amount of compensation will not prevent the expropriating authority from expropriating. Any appeal against the decision of a court on the amount of compensation will not prevent the expropriating authority from expropriating for the amount approved or decided unless a court grants an interim interdict based on compelling prospects of success on appeal. The committee opposes this clause as any dispute or lack of finality relating to compensation should halt the expropriation process until finalized. Clause 20, subsection 9, an expropriating authority may at any time during temporary use of the property commence with the expropriation of the property and must comply with all relevant provisions of this act. The committee opposes this clause. Okay. Why it's not in there as the clause 29? Like you did clause 19, subsection 8, and the clause 20. Anyway.
I'll just put it in. I think it's all part of that.
Yeah, okay, like that. The committee opposes this clause if the expropriating authority determines that it wants to proceed with a permanent expropriation. This process should begin anew once the position has been restored. Otherwise, this will unfairly prejudice the owner and place the state in a superior bargaining position. When property is taken for a temporary use, there is a realistic expectation that it will be returned. Government should not be allowed to negotiate from a position of already being in possession of the property. Okay. 20, clause 20, subsection 10. If the property in question is damaged as a result of the performance of an act contemplated in subsection 1, the expropriating authority must repair to a reasonable standard or compensate the affected person for the damage after delivery of a written demand by the affected person without undue delay. The committee proposes that greater specificity is required in respect of who determines the standard of damage and the quantum of damages. Clause 21, subsection 1A, notwithstanding anything to the contrary contained in any law, the expropriating authority may withdraw any expropriation from a date mentioned in a notice of withdrawal if the withdrawal of that expropriation is in the public interest or the reason for which the property was expropriated is no longer applicable. Public interest is too vague for this section. The purpose for a withdrawal is extremely important. There should be a very limited list of specific circumstances in which withdrawal can happen. The inclusion of this clause supports the need to have a very thorough process of investigation at the outset in order to ensure that there are no mistakes made later that are difficult to rectify. Clause 21, subsection 3. If an expropriation of property is withdrawn, A, ownership of the property concerned again vests from the date contemplated in subsection 1 in the owner from whom it was expropriated, and any mortgage or other rights discharged and expropriated in connection with or as a consequence of the expropriation are fully revived. B, the registrar of deeds or the registrar of any other office at which such expropriated right was registered or recorded must, on receipt of a copy of the notice of withdrawal, cancel any endorsement made in connection with the expropriation in his or her registers and on the title deed in question. And C, the expropriating authority is liable for all reasonable costs, damages, and damages incurred or suffered by a claimant as a result of such withdrawal.
It is a direct matter to the act. Now it's
Okay, can you go up? If expropriated property is withdrawn, okay,
yeah,
and
so
then?
that's close.
Yeah.
Yeah, so now we continue with what is proposed.
Okay, so this section appears to be a contradiction of subsection 2B, which states that where the expropriated property is lent, the property has already been registered in the name of the expropriating authority. Ownership only takes effect when property is registered. So subsection 2B applies and this clause is superfluous. The committee believes that this subsection should be removed and that subsection 3B and C can be retained. Furthermore, the mortgage would have been paid off and the account closed with the expropriation, so it cannot just be revived. It would be a new application and in all probability at the prevailing market price, which would be different to the original mortgage. This would be extremely prejudicial to the owner who might have paid a far lower mortgage price for many years and who now has a new mortgage with new terms and conditions. Can you go a little bit up? Okay, so can we say the committee so that it did sort of give the indication of the feeling of the committee there? Because even when I was reading it, somewhere I got lost in the, yeah.
Yes.
Yeah. Then it will sort of flow to make sense that is because I was also
Section be a contradiction in that.
yeah. Yeah.
So this clauses, let this clause be reconsidered. Reconsidered as it appear.
As it appears.
Mm.
Okay.
It is.
Safe.
same.
Okay, thank you. Then we can continue now. It makes sense. Okay, we are on clause 22. Subsection 3. Whenever a document must or may be delivered in terms of this act, it must take place by delivering A, to the owner and holder of an unregistered right in a property known to the expropriating authority at the address appointed in the notice in terms of section 7, subsection 1, the notice of expropriation, the notice in terms of section 11, subsection 2, or another document as the case may be, and B, to any owner holder of an unregistered right person who has lodged on objection or submission contemplated in section 7, subsection 2H, expropriated owner and expropriated holder at the address of personal or fax number appointed by such person in terms of this act or in the absence thereof. Roman figure 1, at an address supplied in respect of such person in terms of this act. Roman figure 2, at the residential or postal address of such person, if known to the expropriating authority, or Roman figure 3, if no address of such person is known to or readily ascertainable by the expropriating authority by publication in a manner contemplated in subsection 2A. A notice as per subsection B, Roman figure 3, is insufficient, and any person whose interests are affected must be properly notified of the expropriation process. This cannot be left to their chance that they see a notice in a local publication, and more effort must be made to ensure that the person is notified appropriately. The inclusion of email as form of communication has been omitted, and reliance is where was I? Reliance is placed on only post, hand delivery, and fax as a form of communication. Email as well as the office of the sheriff must be included as a form of communication for the purposes of this clause. Yeah. And then clause 25, subsection 2, a civil court may impose a fine up to a maximum prescribed amount in favor of the National Revenue Fund on a person referred to in subsection 1 upon application to the expropriating authority brought on notice to the affected person. The committee is concerned that the minister is authorized in section 26, subsection 1D to determine the final amount. This leaves too much discretion to the minister. There should be instead be a framework or frame of reference for the determination of a suitable fine, or alternatively, the bill or regulations should specify an amount itself. Clause 26, subsection 1D, the minister is given the power to determine maximum civil penalties when this could instead be determined within the bill or regulations itself. Clause 27, subsection 1, Roman figure 2, a regulation or notice or an authorization document made or issued in terms of this act, B, may be amended or replaced without following a procedural requirement of this act if, Roman figure 2, the correction does not change the rights and duties of any person materially. The committee proposed a technical amendment to this clause. The use of the word "and" means that both rights and duties must be affected for these provisions to allow the change to be made without following a procedural requirement. It is proposed that "and" be replaced with "or." It is also suggested that interests be included so that the provisions reads as rights, interests, or duties. And other general concerns, put it?
It is also proposed, not suggested.
Yeah.
Okay.
Also proposed that interest say all the time. Okay, on the general concerns, proposed amendments on on general concern and proposed amendments. The following amendments were tabled in National Assembly. It is our recommendation that this be major focus for the NCOP engagement. Is the existing provision clause of expropriations, which means the compulsory acquisition of property for a public purpose or in the public interest by an expropriating authority or an organ of state upon request on an expropriating authority. An expropriate has a corresponding meaning. Proposed amendment, expropriation means the curtailment of the rights of an owner in property for a public purpose or in the public interest by an expropriating authority or an organ of state upon request to an expropriating authority through Roman figure 1, compulsory acquisition of property at a form of direct expropriation or custodial taking or regulatory taking of property in the case of indirect expropriation. Okay, go on. That's the question. We talked about the issue of the meaning of the property and we talked about the immovable. So in our proposed amendment, are we not to talk about acquisition of the immovable property or land?
Yeah, it was a property or land, yes.
Yeah.
Property.
Advocate Master?
As a form of direct expropriation.
Yeah.
We did say property or land.
Yeah. Advocate Master? I was asking Shumis because of the recommendations of blah, blah, blah. On the proposed amendment, I said, isn't it, we said, rather than saying the property, we can say immovable property or land, because that is our proposed amendment to the bill. So we need to put it in that way when coming to us on the, okay. So immovable property or land as a form of direct expropriation. Yeah, it's perfect that way. Okay. So the proposed amendment is, I'm done on that, compulsory acquisition of immovable property or land as a form of direct expropriation or custodial taking or regulatory taking of. You are going to replace immovable property or land. So on our proposed amendment, where there is a property, we replace with immovable property or land. Okay. See. Okay, that is the proposed amendment and determination of compensation. Section 12(3), it may be just and equitable for nil compensation to be paid where land is expropriated in the public interest, having regard to all relevant circumstances, including but not limited to A, where the land is not being used and the owner's main purpose is not to develop the land or use it to generate income, but to benefit from appreciation of its market value. B, where an organ of state holds land that is not using for its core functions and is not reasonably likely to acquire the land for its future activities in that regard, and the organ of state acquired to land for no consideration. C, notwithstanding registrations of ownership in terms of the Deeds Registries Act 1937, Act No. 47 of 1937, where an owner has abandoned the land by failing to exercise control over it. D, where the market value of the land is equivalent to or less than the present value of direct state investment or subsidy in the acquisition and beneficial capital improvement of the land. And E, when the nature of the condition of the property poses a health, safety, or fiscal risk to persons or other property. The proposed amendment is, it may be just and equitable for nil compensation to be paid where land is expropriated in public interest, having regard to all relevant circumstances. Where an organ of state holds land that is not using for its core functions and is not reasonably likely to require the land for its future activities. In that regard, and the organ of state acquired the land for no consideration. Okay. Where previously expropriated property is expropriated for a new purpose. Okay, where previously expropriated, a movable property or land is expropriated. Do we slot in there or we leave it with property?
Leave it.
We leave it with property is expropriated for a new purpose from an organ state or state department, and compensation has already been paid.
Otherwise, it's going to change other clauses.
Yeah, so importantly, so the general comments, members, I need your input on the general comment. No, the general comments, it's our general comments about the so we said, the committee noted with concern the submissions received during most of the public hearings were not relevant to the expropriation bill, but rather fell within the scope of the restitution and land reform or spoke to the service delivery issues. Unfortunately, most of those submissions could not be considered in the formulation of the negotiating mandate of the provincial legislature.
It was written and oral.
Written and oral, all submissions were. Concern was raised that the time frame for the legislation to conduct. Okay.
Yeah.
Concern was raised that the time frame, so the time frame allocated for the legislation.
Time frame.
So I want to say the concern was raised about the time frame allocated for the process for processing this legislation. Yeah, for the legislative process. Okay. Concern was raised that the time frame allocated for legislative process was insufficient.
Process
Was insufficient. Because we want to highlight the issue of the public hearings and not. Okay, members, Leku.
No, Chair, I think in terms of the time frame, I think the NCOP, they've got their own time frame that they would give to a legislature in terms of their processes, by when their process should be concluded in terms of public participation. And I'm not sure if, because I'm under the, because they do give you time unless you ask for an extension. But initially, I think they would have their own rules and say, okay, if a matter is referred to the legislature by a certain time, then they should have concluded.
So you can say it as you question and say, how do you want us to do this? So you and
No, I think, Chair, what you say, we need to be straightforward to them and say that, not enough time was given to us. Not enough time was given us to be able to get, the views from our community. Because we all know that they gave it to us because they are pushing, and you need to be blunt and tell them that, you.
So the simple English, not enough time was allocated to us to engage with the communities.
Yeah, to do proper public participation.
To do proper
public. Yeah. And I think also the issue of the presentations, that it was done in a language that the majority of people It did not speak to
the presentation, but national department.
yeah, because it's national, because you go to George, where the majority of people is Afrikaans speaking. You get someone from Limpopo who does not understand a word of Afrikaans to do a presentation in English, and it's high English. What do you expect? You won't get proper Nuka comments. You don't get a proper
But remember that, isn't it not the process of public hearing, our responsibility that the translations we have to arrange, knowing that we do have the community members that speak another language, that we have to arrange the translations to make sure that our communities, don't you think is our responsibility to make sure that that is the case?
The presentation, we don't do the presentation. Remember now, we are not the presenters of this bill. It's a national bill. Even the documentation, they must bring their own documentation.
Yeah.
And you cannot dictate. Remember now, we are different spheres. One sphere cannot dictate to another sphere how they conduct their business. But what we are raising is we are raising a concern as residents of this particular province to say these are the concerns that were raised. These are the concerns that we felt on the ground.
Okay. So look, I understand what you are saying, but translation, our responsibility. Presentation, maybe if we receive the presentation beforehand, translated in Xhosa and Afrikaans, then we'll be, because as we compile the packages, the presentation that we receive, we put there and always it's in English. So maybe it's what we have to say, but I'm a little bit skeptical about the issue of translation, because it's our responsibility for the translations to make sure that our communities hear us. Advocate Masdor?
Yes, I agree with you, Chairperson, but I think it needs to be said, and one is so mindful because one almost expects that this matter is going to get to court, right? So we want to present on the record that it was not just about having a public participation hearing. It was the need to have quality participation by the public. And their participation presupposes an understanding of the content in front of them. So there needs to be, in as much as we are different spheres, there needs to be some collaborative attempt between us and the presenters to ensure that there's a measure of understanding, that the depth of quality is ensured when people are confronted with this content, this high-level content, So that observation is certainly warranted. But maybe just the following, Chairperson, in respect of the first paragraph, the committee noted with concern the submissions received which did not fall within the scope of, etc. I'm not sure if that is for the attention of the NCOP. We did raise the issue in committee earlier, where we said that people were talking about land reform, etc., as opposed to expropriation and the processes involving that. I think I also raised that point. What I wanted to highlight, and I actually want to suggest that that be removed because it's not for the attention of the NCOP. However, it is for the institution's attention to say, listen, guys, when we get a bill as substantive as this, we need to have more time with our PEO, our officials, and drill it into the community. When I was, for example, responsible to assist with the drafting of the Liquor Act, we went throughout the province. Every second person complained about the Shabin in their road and the proximity of a tavern to a school. Things unrelated to the bill as it was at the time. So people have frustration and they want to talk whenever public representatives come, but it's our duty to ensure that it stays on point within the bounds of respect. So I think that should be removed. It's not for the NCOP. It's in fact a call for us to jack up our engagement and our preparatory work when we take proposals of laws to the community.
Chairperson, through you, don't you think, Advocate, that we can marry the first one with the second one? Because it speaks to each other and we want them to understand. Maybe the reason why the people didn't understand is because of, yeah. And then we bring the language also in there as part of the whole thing. The one thing that bothers me is if you can help me, I'm not English. Where's the second one now? The reason, there was something, the reason. Oh, it's out there. Took it out, okay. It's fine. Thank you.
Maybe Chairperson, and I'm gonna sort of think while I'm talking. I like what Member De Villiers is saying. So maybe we could package it in the following way: that the committee is very aware and mindful of the timelines and the cycles that are in effect for the lawmaking process. However, mindful of that, the committee has a concern that the time allocated for this particular bill was insufficient in the following respects. And then we say, no, okay, I won't be able to repeat what I'm saying now because where are you now?
Do we possibly have any kind of indication of how our public participation processes differed from that of national, NCOP, or other provinces? Do we have any indication of how our public participation processes maybe differed from national or provincial or other? Because I think, and I'm assuming based on how much we actually have done, despite the fact that it's not enough and I don't know how much more we could do, but with the timelines, I'm assuming that they haven't done an adequate amount as well. And I think that that might also be worth highlighting if we have that information. Otherwise, we could be sitting here all day. There was insufficient, not there insufficient. Chair, there should just be an and after two and the, what do you call it, semicolon hyphen thing. Yeah. But were not relevant. Okay. But were not. So were related to land reform.
I'm sorry. Yeah, no. Okay. It was against the above background that the committee requested an extension to conduct additional public hearing, but was only afforded 1 week within which to host the hearings. And that, honorable members,
Can we adopt?
it is our negotiating mandate. Can we adopt? Member?
Okay, I move that we adopt finally.
Thank you very much, member. Kayla Mari, any seconder? Chidimo?
Mbulelo Isaac Selego, second there, Chair. Thank you very much.
Thank you very much. And that
To just print and then sign.
is duly adopted. If we can just print and I sign, and then I don't have to see you tomorrow. Advocate Masdorp, you are most appreciated. And Shamis Lizette, you appreciated more after I signed that. My favorite members, you are also appreciated, and that is your negotiating mandate. You will get the copy of that, and meeting is adjourned. Thank you very much. Ladies and gentlemen, Masinde, in absentia, Shamis.
Yeah.
You?
And obviously read these minutes, that we adopt them in total. Thank you.
Thank you very much. And member, seconder for adoption of the minutes.
I second you.
Okay, thank you very much.
Annual report and the annual report.
And the annual report, so that you don't have to come back to adopt the annual report. Member,
Propose we adopt.
thank you very much, seconder.
Second, Chair.
Okay, member, minutes. Second to the adoption of the annual report. And then which one also? That's all.
Yeah.
And then that being said, with the last adoption, the members, thank you very much. Meeting is adjourned.